Good morning and welcome to the Joint Standing Committee on Innovation, Development, Economic Advancement, and Business. This committee is assembled today in order to invite public comment on legislation. Before we get started, I wanted to share some information related to the fact that we are doing this via Zoom. The meeting is currently being live streamed on our YouTube channel, and you can find that by going to legislature.maine.gov, clicking on committee, clicking on the Innovation, Development, Economic Advancement, and Business Committee, and then you could select the YouTube channel. That's the best way to get through. In a moment, I'll ask committee members to introduce themselves. Before I do, I'll remind everyone to double check your titles. Okay, we all have them, and I think we're all getting pretty good about mutes and unmutes and figuring that out. Let's see. At this point, I ask the committee members to introduce themselves. Representative Geiger, can you kick us off?
Yes, good morning. My name is Valley Geiger. I'm representative for District 93, Rockland and Owl's Head.
And I guess I'm Senator Scott Searway, represent District 16, which covers Waterville, Winslow, Fairfield, Benton, Albion, Clinton, and Unity Township.
I'm Sarah Pebworth. I represent House District 133 in the Blue Hill Peninsula.
Good morning. I'm Representative Jack Dearshire. I'm representing House District 111, Madison, Solon, and Norridge Walk.
Good morning. I'm Representative Sue Austin. I hail from, excuse me, I hail from Gray, my hometown. I have most of Gray. I have portions of Raymond. I have portions of Casco, which is a neighbor, and I have all of Fry Island.
Is Representative Hassenfuss with us? I don't see that. Representative Bailey.
He's connecting right now.
Okay. Representative Bailey, go ahead. Oh, there you are. Representative Hassenfuss.
Thank you, Mr. Chair. Representative Tavis Hassenfuss, Winthrop, Reedfield, and part of Monmouth.
This is Representative Kyle Bailey. I'm not fighting with children about putting pants on this morning. I represent House District 27, which is part of Gorham and a small part of North Scarborough.
Good morning, everyone. I'm Sue Bernard. I represent District 149, which is Caribou, New Sweden, and Westmanland.
Good morning. I'm Representative Tiffany Roberts, your House Chair, representing House District 6, which is comprised of the majority of North Berwick and South Berwick.
And good morning. I'm Senator Chip Curry, and I represent Senate District 11, which includes the 26 rural, coastal, and island communities of Waldo County. Couple more announcements for the functioning of this committee. A reminder to those in attendance that the chat function is, boy, I do this every time. I'd like to stop that, and I will introduce our committee clerk, who is Jody Breton, and Jody Breton is integral part of our process today because she will be supporting the live stream as well as the YouTube, as well as the Zoom, navigating people in and out of the committee. And Ms. Breton, if someone is having any technical difficulties, what email should they email?
idea@legislature.maine.gov.
So it's IDEA
Yep.
at legislature, okay, at maine.gov. Great, thank you, and welcome this morning. And also we are supported by our legislative analyst, Ms. Rachel Olson. And are you there, Ms. Olson? Oh, I'm on two screens. Thank you very much. Welcome.
I am. Good morning.
And with that, a reminder that we'll be using the chat function only for any technical issues, no substantive conversations. I think with that, we will open we've covered all the announcements. So unless there's anything else I missed, Representative Roberts, Chair Roberts, is there anything I missed? Let's go ahead and open our first bill. So public hearing, we'll open public hearing for LD 1533, an act to amend the foreign credentialing and skills recognition revolving loan program. Is Representative Cloutier in the attendee list? Can we bring her into as a panelist? Welcome, Representative Cloutier. The floor is yours. You have our attention.
Good morning. Thank you so much. And thank you also for having me up first today so that I can get to my own committee meeting at 10. So Senator Curry, Representative Roberts, and distinguished members of the Committee on Innovation, Development, Economic Advancement, and Business. As you know, I am Kristen Cloutier, and I proudly represent House District 60, part of Lewiston, my hometown. And I am here today to present LD 1533, an act to amend the Foreign Credentialing and Skills Recognition Revolving Loan Program. The Foreign Credentialing and Skills Recognition Revolving Loan Program, created in the 129th legislature and administered by the Finance Authority of Maine, provides interest-free loans to foreign educated or foreign trained experienced immigrants who need assistance while awaiting federal employment authorization to pay the costs of certain actions and activities that will improve their work readiness once they receive their work permits. This bill makes amendments to the program, which include adding the costs of the filing fee for an immigrant's initial work permit application as a loan eligible expense, defining initial work permit, ensuring that a change in federal regulations will not require a future statutory amendment of the provision of the program governing eligibility under the program, and in the provision governing eligibility under the program, changing a specific time frame while waiting for asylum to be unspecified time period, while waiting on an application for asylum or other immigrant benefit or relief. Despite the pandemic, and in some ways exacerbated by it, Maine continues to face a workforce shortage. I'm sure you hear about this every day in your committee. This bill helps to fill some of those gaps by expanding support for immigrant populations across the state who are here legally, as a way to get them into the workforce faster and on a path to self-sufficiency. Many people who are either already present or coming to the state of Maine now, particularly our asylum-seeking population, are highly educated. They are biochemists, doctors, nurses, lawyers, and engineers. These amendments will help them to receive clearance to work from the federal government and to assist a highly educated and skilled segment of our population to attain the credentials they need, apply them to the education they already have, and to become even more productive and contributing members of our local communities. This bill helps to get more people prepared for the jobs that Maine employers need to fill today and into the future. I'm honored to be able to present it, and I'm happy to answer any questions you may have.
Thank you very much. Does the committee have any questions? Seeing no questions, thank you very much, Representative.
Thank you.
And Ms. Breton, if you could bring in, I think we can do the, if you could bring in 3 folks, Mr. Norbert, and Morgan, is that Representative Riley and Ms. Stickney? And we'll start with Representative Riley.
I do not see Representative Riley in the
Okay,
attendees.
so we'll start with Mr. Norbert.
Good morning. Thank you, Senator Curry, Representative Roberts, distinguished members of the IDEA Committee. My name is Bill Norbert. I'm the Government Affairs and Communications Manager at the Finance Authority of Maine. And I'm pleased to be here today in support of this bill, LD 1533. As you heard from Representative Cloutier, it makes 4 changes to the program. And we're pleased to support it because we think it will help garner increased interest in the program, and help improve the program as well. As the representative sponsor mentioned, the idea behind this program, it's a relatively new program, is to help Maine's workforce needs and to help those who have skills but need some upfront expenses to qualify for work permits to have these small loans. They're limited to just $700 loans. And these are interest-free loans, and they must be repaid. But when we think about the state's workforce development, the strategic plan, as well as the recent Economic Recovery Committee recommendations, this program aligns really well with those recommendations. You recall from the 10-year strategy, one of the action steps is to engage today's workers in continuing their education to achieve credentials of value for career advancement. Another action step is to increase the labor force participation of existing residents. And yet another is to help new Americans and other newcomers become qualified to work in Maine. There's also a recommendation in the Economic Recovery Committee's report that talks about FAME being a vehicle for administering loan and grant programs like this that are targeted at historically disadvantaged groups. Talent development is a key recommendation, as you know. So we support these changes. I'm happy to answer any questions you might have. Thank you.
The chair recognizes Representative Roberts.
Thank you, Mr. Chair. Mr. Norbert, how are you today?
Very well, thanks. And you, Representative?
Good. Just to kind of circle back, because we've talked about this program before.
Yes.
And I'm wondering if this has a fiscal, if you anticipate this has a fiscal note on it, because I know that we had made a recommendation to AFA to decrease the amount allocated to you for this specific program, correct?
Right. Yes.
So I'm just kind of wondering how that all meshes together as far as what our recommendation was, and if that's
sure
probably not a good idea now, or is this covering that, or kind of where that all lies?
Sure. My understanding is that, first of all, there would be, these changes would impose no fiscal impact on FAME as an agency for administering the program. We can absorb the change. But your point was about the budget process, which is still pending, although the biennial budget continued the flat funding of $75,000 a year for this program. As you well know, this committee made report back recommendations to the Appropriations Committee, which are under consideration now. And those did include reducing the funding, I think it was to 50,000 per year instead of 75,000, and using the additional 25,000 per year for the 2 years toward, I think, the Maine State Grant Program. So that has yet to be decided by appropriations if there's to be a supplemental budget. But no, as you know, without any other changes, this program still is in the biennial budget and slated to receive funding. Recall, there's about 150,000 total right now in the program that has not been used. Remember, there have been no loans made yet. We do expect, and you'll hear from Attorney Stickney, who will be speaking soon, we do expect increased use. There was some holdup at the federal level with some regulation changes. There was an expectation of a new administration making changes, and now there'll be these changes if you support them, and the word will get out, and we do expect to be making loans soon. I hope that helps.
Yes,
sure.
Yes, thank you.
Are there any other questions for Mr. Norbert? Seeing none. Thank you very much.
You're
I
welcome.
see that Representative Riley is now in the panelist list. If Representative Riley, you have the floor. Actually, I think you are in the attendees. Thank you, Ms. Breton, for promoting Representative Riley. Welcome, Representative Riley.
Thank you. Thank you so much for having me here this morning.
You have the floor.
Great. Awesome. Good morning, Senator Curry, Representative Roberts, and distinguished members of the Joint Standing Committee on Innovation, Development, Economic Advancement, and Business. I am Morgan Riley, and I represent House District 34, which includes part of Westbrook. I'm here today in support of LD 1533, an act to amend the Foreign Credentialing and Skills Recognition Revolving Loan Program. LD 1533 will amend the Foreign Credentialing and Skills Recognition Revolving Loan Program to mirror federal regulations in 4 aspects. 1, it adds as a loan eligible expense the cost of the filing fee for an immigrant's initial work permit application. 2nd, it defines initial work permit Third, it ensures that a change in federal regulations will not require a future statutory amendment of the provisions of the program governing eligibility under the program. And lastly, in the provision governing eligibility under the program, changes a specific time frame while waiting for asylum to an unspecified time period while waiting on an application for asylum or other immigrant benefit or relief. LD 1533 will help address Maine's workforce shortage by helping legal immigrants to enter the workforce quickly. Maine has a highly educated immigrant population, especially our asylum seeker community. This bill will make it easier for them to receive the credentials they need to utilize the knowledge and specialized skills they already have and join Maine's workforce. In turn, this will empower them along with helping communities across the state and strengthening our economy. Thank you so much for your time and consideration. I hope you join me in supporting LD 1533.
Thank you very much, Representative Riley. Chair recognizes Representative Bailey.
Yes, thank you, Mr. Chair. Representative Riley, I know that you've done some work in the immigrant community and have authored a book and working with immigrants. Have you come across some, excuse me, some personal stories about how people have been impacted or challenges that people have faced? It would be helpful just to shed a personal experience on what the implications of this bill might be.
Thank you, Representative Bailey. And I can't share specific names or specific experiences, but I mean, this bill will help a lot of the communities like here in Maine. Many of them come from a highly skilled background. They have degrees in engineering, advanced degrees in multiple fields that would be really helpful for here. For Maine's economy. I've worked with actually Beth Stickney before. I volunteered with her Maine Business Immigration Coalition, and I don't know if she's testified or not already, but she can probably talk more specifics on that.
Chair recognizes Representative Austin.
Thank you, Mr. Chair. Welcome, Representative Riley. I want some clarification if we can. You mentioned it shortens the time. Can you just explain that one again? Because if I remember correctly, there was a lot of concern, and it's been a few years since that particular issue was shared with me, that when they arrive, isn't there like a 5 or 6 month kind of almost like a holding in place pattern for them that they can't really reach out and get connected? And I'm assuming that this is going to help them do it, because you said something about getting them up and going and into perhaps a profession or some work situation much faster. Can you kind of help me on that one?
Thank you, Rep. Austin. Yeah, I would direct that question to Beth Stickney. That's a pretty technical question regarding just because I have had some experience working in immigration law before. I was just a paralegal, so I can't give any legal advice. And it is a field. It's a field where the laws change very quickly.
Thank you.
Senator Searway.
Thank you, Mr. Chair. Good morning, Representative Riley. We haven't got to meet yet, but you know how it is with this COVID situation, I guess. But,
yes. Yep.
Anyway, I just have some concerns. I was talking to this person that works in the field of getting immigrants into the workforce. And she had told me that it's very difficult because of the language barrier and also getting records of any skills that they may be certified in. They claim that they may have, but they may not, but they try to get the records and they can't get them. So how's this work in that situation?
Again, thank you, Senator Searway, for your question. Again, like Rep. Austin, I would, sorry to, I don't mean to, I'm not trying to avoid your question or anything, but Beth Stickney can speak to that question specifically, just because of her her day-to-day experience and her absolute breadth and wealth of knowledge on that, about those issues, that she could answer that question much better than I could.
All right, thank you.
Thank you. And I seeing no other questions, we'll go right to Ms. Stickney. And welcome. You've heard the last two questions that Representative Austin, Representative Searway said. Would you like to, well, you can actually go ahead and deliver your testimony, and then we'll get to questions.
Thank you, Senator Curry, and good morning, Representative Roberts and honorable members of the committee. I think I will dispense with reading my testimony. You've got it in writing, and I'll try to jump to the questions, some of which are somewhat answered in the testimony. In terms of the reason why we needed this amendment, really everything is just a technical amendment, but essentially back when this bill was drafted, asylum seekers and others applying to adjust to permanent resident in the US didn't actually have to pay for their very first work permit. After they have a job, they have to pay for their next work permits, but their first work permits they didn't have to pay for. The Trump administration changed the rules after this law was enacted, the statute was enacted, to, for the first time ever, since the Refugee Act of 1980, require asylum seekers to pay for their first work permit. And they also raised the fee for a work permit to $545. So we realized, oops, we didn't account for that when we drafted the bill. And so we added the work permit in as an allowable expense, because the whole point of the bill is to make people work ready. And if they can't get a work permit, they by definition are not work ready. So that was one change. And even though the Biden administration has actually rolled that back, because of the awareness that federal law can change in the future, and we don't want to have to keep running back to the state legislature to tweak the law every time there's a federal change, we wanted to add that, the work permit fee as an allowable expense. In addition to Representative Austin's question, Maine cannot change, obviously, federal law, but in the drafting of this bill, we made specific reference to the fact that asylum seekers have to wait 150 days before they can file their work permit, and realized, because the Trump administration changed that and said they would have to wait 365 days, a full year, before they could request a work permit. And again, the Biden administration has now rolled that back. But if there is a future administration that wants to lengthen that time, or all of our, both of our senators and Representative Pingree have actually proposed reducing the wait time. So if there is a future change making it a shorter wait before we can apply, we, again, don't want to be having to rush back to your committee saying, please change the law. So we changed it to be more generic language that just refers to any wait period that might be required under federal statute, as opposed to saying 150 days. In terms of, and I don't know if that actually answered that part of Representative Austin's question. In terms of Representative Searway's question, there are several other bills pending this session, one of which is going to have actually floor debate tomorrow. Representative Cloutier's bill, LD 149, which would give the Department of Professional and Financial Regulation more flexibility to assess foreign credentials and the skills of people who have gotten their education and credentials from abroad. And that is to try to prevent this problem of brain waste that we have, where Representative Riley and I were working together. It was for an employer in Westbrook, American Roots. And we were doing some work with some of their employees. and many of whom were, again, sewing clothes and then eventually sewing PPE, which we desperately need. The company pivoted to PPE, but many of them had, higher education in their home countries and were prevented from getting into their jobs because of difficulty in getting their credentials recognized. So there is another bill that deals with that issue. This bill, the statute that exists already allows people to apply for the FAME loan to pay for, when they actually have their credentials, getting those credentials translated and evaluated, a cost of usually $500 to $600 to do that. And if you're an engineer, you have to get that done before you can apply for licensing from the engineering board. So this,
Stickney, can you wrap up in the next couple sentences?
Sure. So LE 1533 doesn't change the fact that the loan fund is already trying to take care of that expense. It just makes this law function better in perpetuity if there are other federal law changes to work permit rules, et cetera. And if I didn't get to all of Representative Austin's question and Representative Searway's question, I'm happy to take more questions.
Thank you very much. I see Representative Austin. The floor is yours.
Thank you, Mr. Chair. Ms. Stickney, thank you. So I hope I'm not putting you on the spot, but you're working in this area, and I know that that time frame of waiting, kind of lingering on the vine, if you will, was an issue, and it appears it was an issue, and it might have got even more extended, and now it's come back. Did you must have been aware of why would that have been extended to a year? Do you have any sense of that?
I can give you no other explanation, Representative Austin, except for the prior administration was just extremely hostile to asylum as a concept and was doing everything it could to basically dissuade people from coming to the country and applying for asylum. And if you force people to wait for a year, I think the thought behind it was people will say, we'll go to Canada instead, where we can start working more quickly, rather than coming here. There was no rational basis, particularly given pre-COVID, not just the unemployment rate in Maine, which had been at historic lows for more than 4 years, but in the entire country, our need for workers. There was no economic-based argument, and there were so many other steps taken by the administration to try to dismantle the asylum system that is the only explanation that is plausible.
So you, excuse me, so you don't think it was in any way thorough investigation of health, medical reasons or health backgrounds or any of that pre-COVID?
No, and in fact, in the preamble to the federal rule, when they changed that waiting time, they actually they're required to evaluate the costs of any federal rule change. And in their preamble, they talked about by making this rule change, they were going to be increasing costs to safety net programs, and that it was going to cost employers billions in, lost access to a workforce, and in productivity because they wouldn't have sufficient workers. So there was no rational, economic basis for this change.
Have you worked at all? I know you mentioned Roots, and I believe Abbott Lab has a very sizable employee base of some of our new Mainers. Are you familiar with that?
Yes, there are many, many companies in Maine that are, have relied quite heavily on the immigrant workforce in order to be able to maintain their workforce or to grow. And so that includes everything from LL Bean to Abbott Labs to Puritan and the Swabs to, they've tried to recruit in the immigrant community, to our seafood processing like Reedy Seafood, Luke's Lobster, just so many industries rely on immigrant labor. And again, the purpose of the original statute that LD 1533 is just making, amendments to improve, was to make sure that people, when they are not able to work, that they can take the steps they need, whether it's driver's ed so that they can driver's license or get their credentials evaluated and, translated and evaluated, or take the TOEFL exam so that they can show that their level of English is sufficient to do whatever job it is they're going to be applying for. And of course, like college board exams, the TOEFL exam has a fee. It's to say, if our government is saying you must sit idle and not be able to earn a living, let's help you do the building blocks so that when you do get your work permit, you can jump into not necessarily just the survival job, but the job that is more commensurate with your skill level. And so that you can work to your highest potential as soon as you get your work permit.
Thank you very much.
Thank you. Senator Sirway, you had another question.
Thank you, Mr. Chair. Ms. Stickney, I just have a question about what incentives are there for these illegal immigrants to become legal and be citizens? Could this be a tool to say, if you'd like this, to sign up to become a legal citizen? Because it seems like we're giving them licenses and jobs and whatever, and there's no incentive to become an American. So what do we do to do that?
Well, actually, when people come here, they have huge incentive to become Americans. That's why they come, is they want to be part of the American dream. And when people are applying for asylum, they are in fact not illegal. They are lawfully present and have lawful status here, and they are allowed under federal law to apply for asylum, whether they come in originally with a visa, be it a student or visitor visa, or whether they present themselves at our northern or southern border and say, I have fled persecution, I need protection. And so the people who are here, nobody in this state gets a driver's license without being lawfully present. That's required by law. And nobody is able to work without a federal work permit. What we do need, though, is our federal, which is unfortunately not in your hands, but our federal immigration system has not been reformed in over 30 years, and it's completely out of date with the nation's demographics and our economy, and needs substantial reform to provide more legal pathways so that people who want to come and do what my, great grandparents did, and most of us, on this screen, can come to try to improve our lives and the lives of our families, and just, work hard and succeed. But that's a federal, we desperately need federal change. And that is actually one of the missions of the Maine Business Immigration Coalition, is to work with Maine's business community to help our federal delegation understand what reforms we need to make at that level, so that there can be more legal pathways. Right now, if you're not an immediate relative of a U.S. citizen or permanent resident, if you're not eligible for asylum or refugee status because you've been persecuted in the past, if you don't have an employer who does a petition and proves before they can even file the petition that there's no U.S. worker willing and able to do the job, or if you don't get tremendously lucky and win what we call the diversity visa lottery, where you got a 1 in 20 million chance of being selected, you don't have a path to legal status here, which just doesn't serve the country at all. Including somebody who gets an engineering degree, their master's at UMO, and has an employer that wants to employ them, may not have a legal path forward because of how outdated our federal immigration system is, even though we need that person.
Thank you very much, Ms. Stickney.
Thank you.
And seeing no other questions, thank you very much for your testimony. Ms. Breton, is there anyone else registered to give testimony on today's bill? On, I've lost our number. What are we on here? LD 1533.
No, there is not, sir.
Okay. With that, we will close the public hearing on LD 1533. And thank you very much. And if you can promote Ms. Stickney, and let's see, if you could I think next bill is one that I am the sponsor, so I will hand over the gavel to Representative Roberts.
Thank you, Mr. Chair. Okay, so this time we're going to open up the public hearing for LD 1517, an act to establish a Maine Workforce Research Development and Student Achievement Institute, presented by Senator Curry. And if you're ready, the floor is yours.
I'm getting ready. Thank you. So once. Representative Roberts, distinguished colleagues of the Innovation Development, Economic Advancement Business Committee. As you know, my name is Chip Curry, and I am State Senator for Senate District 11, which includes the 26 rural, coastal, and island communities of Waldo County. I am pleased to present to you LD 1570, which is an act to establish the Maine Workforce Research Development and Student Achievement Institute. This bill is identical to a bill brought forth by then Representative Daughtry in the 129th legislature, and I'm very glad to be bringing it before this committee once again. This session, the IDEA Committee is hearing dozens of bills that aim to foster a thriving and vibrant economy in our state. In the past few weeks, this committee has addressed strategies for recruiting and retaining a workforce in our rural communities, scholarships and loan repayment programs for undergraduates, nursing faculty, and physicians, regional development strategies for our former military and regional development strategies for our former military bases. We have also considered numerous budget items designed to support students, incubate innovative businesses, and promote international trade. The topic areas this committee is charged with addressing also overlap with many policy areas with which our colleagues in other committees are working, including building or adapting workforce housing options, increasing broadband access, expanding access to affordable high-quality childcare, and promoting apprenticeships as a pathway to high-quality jobs. These are all policy areas that impact economic development and workforce, but often land within other committees. Time and again, I have heard this committee ask for more data. We want to know if the program, tax credit, scholarship, or grant actually does the thing we hope it does. We want to know that we are neither missing a critical opportunity to move the state forward, nor wasting the people of Maine's hard-earned money on well-intentioned but misguided programs. When Senator Daughtry introduced her bill in the previous legislature, she noted her positive experience working with the Maine Education Policy Research Institute, MEPRI, and all the information and policy research they were able to provide the Education and Cultural Affairs Committee. LD 1517 seeks to use MEPRI as a model to establish a research institute focused on the policy areas within this committee's jurisdiction: economic development, workforce research, and student achievement. By creating the Maine Workforce Research Development and Student Achievement Institute, LD 1517 will help us to answer the questions that are most pressing to this committee and equip us with more comprehensive information to do our jobs well. The Institute would provide credible, objective research that will serve the committee and other parts of the legislature as we craft policies that will make a real difference in Mainers' lives. I thank you for your consideration and would be happy to answer any questions you may have of me.
Thank you, Senator Curry. Are there questions from the committee? Representative Pebworth.
Thank you, Ms. Chair. Thank you, Senator Curry, for bringing this forward. I have two little questions, I think. One is, the Institute is established to collect and analyze information related. I'm curious about the word barriers, if that a little more focus on that might be helpful. So that's one question. And then when we're talking about membership, one member employed in the public sector, one employed in the private sector, that's pretty broad. And I didn't know if narrowing that a little bit might be helpful as well.
So I believe some folks that will be coming later to speak on this would also speak to the issue of membership. So the concept is that there's a steering committee, and how it works is, my understanding with MEPRI is there's a steering committee that will brainstorm a bunch of ideas of what should be studied. And typically there might be 4 to 7 studies in a given year. They'll brainstorm those ideas and they bring those back to this committee. And this committee would rank those and say, what do we really care about hearing about? What do we need to know in order to shape policy? It's not going to have any positions on legislative, like any positions about how to vote, but what is the information we need in order to shape our policy? And so the membership is really to make sure that it's broad, because we want this broad enough so that it is credible, that it's not just a partisan thing, that it has the representatives from various stakeholder groups, and so that it will serve this committee. Does that help? I mean, so when we get at barriers, it depends on what we want.
Senator Steerway.
Thank you, Madam Chair. So what would the cost of this be, and what would they have, like a headquarters, or how would this all work?
I believe the model from MEPRI, that serves the Education and Cultural Affairs Committee, is, I believe it's about $250,000 with another $125,000 that is in cost share, but that is not a set thing at this point. So it's and it's based, so there's staff, there would be a staffer or a partnership in terms of staff at the university system. So whether that's within UMaine or USM, some partnership in that front. And later folks that will give testimony will speak more to the details on that and how it works within the model that we're basing this off of, that I'm proposing.
Just a follow up, Madam Chair. Just he said, now what?
No, I almost said yes. Go ahead.
right. So for 350,000 or 400,000 roughly, doesn't the University of Maine, or we can get quite a bit of data from them on a lot of information, and it seems like it's a lot of money, and it seems like we could see where we could get from that angle on certain entities of what we're looking for, rather than trying to just get 4 or 5 or 6 ideas for a whole year and spend that much money. It just seems like it's a lot of investment for data. I don't know. I'm just trying to weigh this out. And what's it seem to you that maybe this should, like a collective membership through the university, maybe for data collection, and then maybe see how that works, and then go to this extreme if we had to. But it seems like this is a big step.
Are we working towards a question, Senator Steerway?
Yeah, it's just a big question. I'm just trying to see what he thinks.
I fully anticipate we will be diving into the cost and the benefit on this as we look in detail of it. What what resonates for me on this is that we take votes that have some pretty high dollar amounts, and we get them wrong, and that may be the best money we spent, is to be able to get that research and be able for this committee to be kind of quickly up and running in a fairly sophisticated way of knowing these financial, getting this information. And so I think that excites me for us to be able to have, for this committee to be able to have that information that shapes policy when so many of the bills have some fairly big numbers, whether those are tax credits or whether those are scholarship programs, and knowing what's working, what's the return on investment, how do we best know that information, and so that's what it kind of excites me about it.
So just for the work session, can we hear from somebody from the University of Maine of how they could get this data together and in a cheaper fashion?
I think we have some University of Maine people here testify too. Representative Collmore.
Thank you, Madam Chair. Senator Curry, thank you for your testimony here. One of the things that I noticed in reading over the bill language when you're describing the makeup of the body is in my opinion, it's significant that it's missing K-12 representation, whether it's from public, private, or CTEs, that really, I think, are important to leading into that higher education and workforce development world. And I wonder if you are open to adding that kind of representation to that, because I think that's so important. As we all know, the earlier you start, the better it is for the workforce.
Thank you, Representative Collmore. I think the membership portion of this bill is going to be something that this committee will need to look at very closely. I believe we will hear from a department that a concern on membership as well in terms of the number. And so I think we'll need to, as a committee, to dive into membership, the amount, the representation. I think this bill is kind of the original, and we spent some time on it. So there's a history on the membership of this steering committee that I hope we'll get familiar with and find our path through it.
Are there any further questions from the committee? Seeing none. Thank you, Senator Curry. Ms. Brenton, can you bring in Kate Foy and Catherine Johnson if they're both in the attendee?
Yes, and we also have a co-sponsor in there,
Oh,
Senator Daughtry.
oh, okay. I don't have her on the list here. Yeah, let's bring her in as well, and she can go first. Good morning, Senator Daughtry.
How are you?
Good, how are you?
Can you hear me all right?
Yes, the floor is yours.
Thank you. Representative Roberts, Senator Curry, and distinguished members of the Joint Standing Committee on Innovation, Development, Economic Advancement, and Commerce. I am Senator Daughtry, and I represent State Senate District 24, which includes the towns of Brunswick, Freeport, Harpswell, North Yarmouth, and Pownell. And I'm here today to speak in support of LD 1517, an act to establish the Maine Workforce Research Development and Student Achievement Institute. And once again, I owe you all virtual cookies appearing as a member of this committee. Soon we'll be able to be in person and I'll be able to get you those IOU cookies. As returning members of this committee know, I was actually the first House chair of this distinguished group when it was formed in the 129th. And as a new committee, there were many, many different hurdles, whether it was figuring out what our policy area was, what our jurisdiction was, and how we sort of took this lofty goal of really looking at, Maine's workforce and moving it forward in a deliberative and thoughtful manner. I realized increasingly that, there were a few things that sort of put us a few steps behind from the other committees that were around us. And the bill that's in front of you actually was dreamt up in the chair's office in conversations. I think Sam Warren was there, and I was talking about, the work I had done in the Education Committee and working with the MEPRI Institute. I'm now in my 4th term on the Joint Standing Committee on Education and Cultural Affairs, and I have seen firsthand the benefit of the Maine Educational Policy Research Institute. MEPRI was established by the legislature. For a little bit of a sort of review and institutional history, it was established in 1995, and it conducts work for the Education Committee in the Maine Department of Education. It's a cooperative institute between the University of Maine system and the legislature, and it's based on the campuses of the University of Southern Maine and the University of Maine. MEPRI employs several researchers who, according to them and their mission statement, analyze trends and perform targeted research on topics of interest to education policymakers. Researchers include faculty, professional staff, and graduate students with a wide range of expertise in education. Every session, the Education Committee meets with MEPRI to go over the research work plan and suggest topic areas for projects. If there's a policy idea that we want to know more about, MEPRI was there. If there was a national trend that was gaining steam, but we wanted to know what the potential impact would be on Maine, MEPRI was there. If we wanted to see the ramifications of a law that the legislature had passed, for example, proficiency-based education, MEPRI was there to track the implementation and impact across the state and our schools. MEPRI provides Maine-specific research from the field that helps legislators and policy leaders make informed decisions. And when the IDEA Committee was formed last session, I immediately saw the need for increased research on Maine's workforce, labor pool, economic outlook, and so many other areas, as Senator Curry mentioned. I make this joke all the time, but when you're first elected, and honestly, I think it keeps going every year in the legislature, it feels like session starts, you get your feet on the ground, you're put in front of a fire hydrant of information, and someone cracks it open. It's all coming at you from all different directions. So really, I think the value in this bill is creating and recognizing the need for primary and nonpartisan source based on best research practices. There have been a multitude of bills in front of you in both the 129th and 130th that really would have benefited from more research or a long-term look at the statewide impact. Whether it's looking at the demographics of our state, nursing shortages, nationwide licensing trends, workforce preparation, student debt, tax incentives for startups, pine tree zones. I mean, there are a multitude of issues that would be perfect for an institute like MEPRI to examine. So the bill in front of you takes the model from MEPRI and shifts it to be specific to the IDEA Committee. It would establish the Maine Workforce Research Development and Student Achievement Institute, which, as I said, is modeled after the same makeup, but stakeholders can be shifted. The Institute will definitely need a better acronym than MWRDWSAI, but would definitely be able to work with this committee and advise all of you on matters relating to your jurisdiction. It would help you navigate the complex worlds you've been charged with and really be able to move this committee forward. The idea grew out of working with the university system and a large group of stakeholders in the 129th. And I know that there's many representatives of that initial effort today who can discuss in greater detail, not only the current work of MEPRI, but the need and the real passion behind, creating this new research institute. I also want to just really quickly mention on the funding portion, the funding note does come from paying researchers. And this is not just getting a little bit of data. There's tons of reports which you can actually access. The analysts can find them from your website. You can see that they're a little bit thicker. This is a long-term deep dive. It's not just giving you numbers. It's looking at something from all different angles. So when you're looking at the fiscal note, please keep in mind, this isn't just a quick PowerPoint presentation. This is a long-term, longitudinal study that'll look at an idea from formation through, implementation. So this is not, something that we can make happen with the blink of an eye or, be able to absorb very quickly. This is about creating meaningful data, and that does take time and resources. But as you'll see today, there's a lot of folks here who are passionate partners who want to find a way to make this work. And I really urge you all to, think about how much this can guide and change, the legislature and the IDEA Committee. Last year, this bill was my top priority. Unfortunately, it was one of those COVID casualties. So I'm so grateful for Senator Curry for taking this idea on. I urge your unanimous support, and I'm happy to answer any questions you may have.
Thank you, Senator Daughtry. Questions from the committee. Representative Comore.
Thank you, Madam Chair. Thank you, Senator Daughtry, for your passionate testimony, and I appreciate all of the bills we keep seeing that come back as COVID casualties. And the question that I have kind of plays off of Senator Searway's question about the funding, and you had mentioned that it was to pay researchers, which makes sense. I wonder, as part of that, would we be requiring match from the partner entities? So like if the University of Maine has a researcher on there, would they be providing salary match that would help increase the potential of the board because they'd have more funds?
Absolutely. Obviously, I'll let Ms. Warren speak a little bit more in detail, but the way that MEPRI does work, there is a match. This is not just the state being the entire lift of this. There's buy-in, not only from the university on their end. I can't remember, I'll have to double check if it made it into this draft, but when we were moving this forward in the 129th, we also included language that allowed for sort of outside donations to let a lot of the stakeholders be able to contribute to the cost. Because we recognize that, there are willing partners. In the education sphere, we have groups like Lumina or the New England Board of Higher Education that do a lot of this nonpartisan research. And so allowing that collaboration, whether it's financial or just in, research power, is something that I think is a good idea. And, the university system talk a little bit more about that partnership, but it's not entirely on the state side.
Okay, great. Thank you.
Any further questions for Senator Daughtry? Seeing none, thank you and have a good morning. Next up, we have Kate Foy from the department.
Good morning, everyone. Senator Curry, Representative Roberts, and members of the IDEA Committee. My name is Kate Foy, and I'm the Legislative Liaison for the Department of Economic and Community Development. I'm here today to testify in support of LD 1517. This proposal would, as you've heard, establish a model similar to MEPRI used by the Education and Cultural Affairs Committee, through which the university could conduct research and evaluation to inform policymaking and investments of the legislature, state, and other stakeholders about programs and policies related to economic and workforce development, student debt, and other areas within this committee's jurisdiction. DECD testified in support of this legislation in the 129th legislative session, citing that the department sees this bill as one of the many ways we can measure the successes of our work. This tool will help us to see what programs are working, if we need to adjust to make them better, or if a program has run its course and needs to be phased out. As written, this bill describes 18 required steering committee members and establishes that each member, other than ex officio members, serve 2-year terms and that the steering committee meets at least 4 times a year. The department respectfully requests that the sponsor consider adjusting the steering committee to reflect the legislation that previously passed out of the IDEA Committee in the 129th session. Thank you. I'd be happy to take any questions.
Thank you, Ms. Foy. Are there any questions from the committee? Representative Collmore.
Thank you, Madam Chair. What is the proposed makeup? I wasn't part of the last session, so what is the proposal that you have for the makeup of the board that was passed last time?
So it's in the bill online. It was LD 1342, and we can get that to you. I can email the list. I don't know that we want to read it out loud right now. It's similar, but we did make some changes and actually made the committee, the steering committee 13, or the research institute, I'm sorry, 13 members instead of 18, feeling that 18 was sometimes good work can get lost in too big of a group.
Okay, thank you.
But I'm
If you
happy
could get that
to
list. That would be great.
Yep, I'm happy to get that to Rachel.
Are there any further questions from the committee? Seeing none, thank you, Ms. Foy.
Great. Thank you, everyone.
I see we have Samantha Warren already in the room with us. And Ms. Breton, if you could bring in Catherine Johnson and Ben Lucas as well, please. Ms. Warren, are you with us? Yep, there we
Morning.
go.
Sorry, I didn't know if Catherine Johnson was going next. So
okay.
I apologize. Good morning. I really appreciate the opportunity to be here. Senator Curry, Representative Roberts, and distinguished members of the committee. I am Sam Warren. I am here, and I am Director of Government and Community Relations for the University of Maine System, and we are speaking obviously in strong support of this legislation. As was discussed here today, but I'm not sure if it was explicitly stated, an identical bill was unanimously supported by this committee in the 129th legislature. As you've heard today, and I'll provide a little more detail and answer questions, for 25 years through MEPRI, the University of Maine System has directly provided policymakers with objective data, policy research, and evaluation. MEPRI's annual work plan is developed to align with anticipated needs of the Joint Standing Committee on Education and Cultural Affairs. And a list of possible research projects, as you heard, is first brainstormed by a steering committee, which is chaired by a member of the Education Committee. Currently, that's Representative David McCray, and comprised of representatives from relevant stakeholder groups. So you can imagine the Maine Principals Association, the Maine Education Association, the Maine Superintendents Association, the organization MADSAC representing special educators, Maine Municipal, given the role of municipal government in schools, and on and on. And so members of that steering committee, as well as folks who are invited to participate in the steering committee, like me and Educate Maine and others who are not formally named, but who can inform the work, brainstorm a list of topics, and then that comes to the Education Committee, which reviews those topics, adds any others that are missing, and then each member in the committee ranks the proposals. And on average, as you've heard, between 4 to 7 targeted studies are undertaken each year. And efforts are made to have those available in advance of the committee's consideration of bills, which I'm sure sounds really attractive to you to actually have data and analysis before you get a bill, let alone before the work session as well. It's really important that MEPRI does not take positions on legislation. You can imagine these researchers are, among the most informed folks in the state on some of these policy matters. They do not weigh in on bills, not for, not against, neither for nor against. They do not testify on legislation. Instead, these researchers present through substantive informational briefings to the Education Committee and reports that are available to the legislature and the public. Researchers are very intentional in how they frame their findings, being careful to focus on the committee's possible next steps without advocating for specific legislative solutions. You will never hear them or read them say, support LD XXX or, vote against YYY. They are not weighing in on legislation. As a result, MEPRI research and researchers have maintained the highest level of credibility, even though the subject matter that they're working in can be highly controversial. You heard mention, for example, of proficiency-based education earlier. As the co-founder of MEPRI explained it, and he is now retired, but he said MEPRI doesn't have an agenda other than providing good information and data. As you've heard today, the legislature currently appropriates $250,000 to support this applied research, and the university matches that with a contribution of at least $125,000. Again, this supports co-directors at UMaine and USM, and the research time of faculty, part-time research associates, and graduate assistants. Again, $250,000 is the amount that the legislature is appropriating for MEPRI now in its 25th year. It didn't start out that way, and I'm sure we could go back and look at the funding history. As you've heard, this bill would create a model similar to MEPRI to serve this committee. And you've heard lots of examples today about where that would be helpful. I always think about the conversation that this committee seems to have had both in the 129th and the 130th regarding the Doctors for Maine's Future Scholarship. You heard from nearly 24 medical students, doctors, and healthcare employers in support of that scholarship. They had very compelling stories. They wore white coats, and they had some wonderful national data about physician shortages. And some of you shared personal experience that you've had with doctors in your rural communities who have been trained through that program. But you all questioned at the hearing and at the work session if there was data specific to Maine's needs for physicians, and if there was data to demonstrate how effective this program has been.
Ms. Warren? May I
can
be
wrap it
wrapped
up. You know, when you look over testimony for those bills, not once is there specific data on the outcome of those programs, let alone successes on other states. So this is an example of where MEPRI would really be helpful. I would just close by saying MEPRI does not duplicate current data collection and analysis efforts, including by state agencies, and I've given some examples of that in my testimony. And also in my written testimony, I've shared comments from former legislators, including former Senator Brian Langley, who chaired the predecessor of this committee, as well as the Education Committee, who said that a model like MEPRI is critical and will be even more so in the future as people have trouble figuring out what sources of information they can trust. With that, I'll be happy to answer your questions, and really thank you for taking up this proposal.
Thank you. Are there questions from the committee? Representative Hepworth.
Thank you, Madam Chair. Thank you, Ms. Warren. It's nice to see you this morning. There was a question earlier about adding somebody who represents K-12, and then I'm interested too in reducing the size of the institute. Could you say more about that, please? There's a question.
Absolutely. Yeah, it's been an interesting conversation, because when the bill was initially introduced last session, I believe there were maybe 9 or 10 members proposed for the steering committee. And what happened during the legislative process was something that I loved, and that is, all these groups started coming forward and saying, well, I want to be at the table. And then, if the business community wanted to be at the table, and someone said labor had to be at the, and it kept kind of growing exponentially. And as someone who values a lot of diverse input, that was exciting. But I also appreciated the concern by the administration that, you get to a size that becomes unwieldy. What I can say is, I think what I partially addressed in my testimony is that the steering committee is just the folks you have to include in the process. Now, they don't have to show up, certainly, but they're the folks who you must engage. But that doesn't mean that there couldn't be language that, I'm sure the analysts could help develop that encourages, the steering committee to reach out more broadly. And again, through the virtual meeting process that the steering committee has undertaken over the last year, they are throwing open the doors to more than just the members of the steering committee. So I think at the last meeting I was at, probably more than half of the folks that were on the Zoom were not actually statutorily assigned as members of the committee, but certainly, had good ideas. And so, there's nothing to prevent, it's an advisory body, so there's nothing to limit more voices being at the table than kind of the statutory minimum. And I would say the original bill did include a representative from the MEA, I believe, because the list was largely based on a similar list to MEPRI, where the MEA is represented. And I believe the current list does include someone from CTE. And I would say the university would strongly support whatever the committee feels comfortable with, but certainly there's great value in having CTE represented at the table. I think we had recommended a representative from the Maine Department of Education CTE office. Dwight Littlefield is the name of the individual that's coming to mind. I'm not sure of his exact title, but someone in that sort of statewide, as opposed to someone at a CTE school in a specific community. So I think, again, the steering committee that's in statute is the minimum of who is at the table, and it's incumbent upon the researchers who want to get a diversity of perspectives. But ultimately, the steering committee is just giving you all a list of suggested topics, and you are ranking them. You are deciding what's missing based on what you're hearing from constituents and stakeholders you interact with, and that's what's ultimately just determining the work plan.
Thank you. Could I have a quick follow-up, please, Ms. Chair?
Yes.
Thank you. I would be interested, if the sponsor is so willing, to have the analyst prepare language that would perhaps limit the membership, but also invite others to participate in meetings as they see fit.
Senator Seaway.
Thank you, Madam Chair. I like Representative Pemberth's thoughts there. That's a good idea. I just had a question about, it seems like this group would be all educators, and it didn't seem like it had any business people involved or anybody from, the business community. And I think that would be an important piece. I know, I grew up on a farm, and we used to have the agricultural guy, Chad Arms. I don't know if you know him or not. He used to be the man for University of Maine, for Chad Arms. But every time they saw him coming, they'd run because they know he didn't have the common sense of what farmers actually did on the job. It seemed like there was a piece missing. And so that's what I'm kind of wondering, is that something that you could look at and see what could be fit in there for a membership for somebody from the business world?
I appreciate the question. I don't know the individual you're referring to, and I certainly don't have experiences with our faculty and staff as folks who have a piece missing. They're pretty incredible, and I'm very proud of them. But I will say the university completely supports the private sector being included on the ultimate steering committee makeup, and also I think representatives of economic development type of organizations, whether it's, I think of Northern Maine Development Corp or Aroostook Partnership, groups in specific rural regions that are really working on economic and community development and revitalization efforts. So I believe the bill as it's currently written recommends not only a representative of the business community, but also a representative of an economic development related organization, and what I refer to as the RIM counties, though that's not good statutory language, so the specific counties are spelled out in statute, and the university would very much support those representatives continuing to be on this refined steering committee list. I think you're absolutely right. The business community does need to be at the table. And again, the whole point of this research is to give voices to those stakeholders. So for example, MEPRI goes out and interviews and surveys, teachers, surveys superintendents and principals. And so the whole point of MEPRI is to really go beyond the data that kind of the state naturally collects. I use an example in my testimony about teacher recruitment and retention. Maine DOE has data on, teacher turnover, the average, years of experience that educators in all Maine schools have, information about turnover. They have that all because schools are required to report it to the state. But when our researchers went out and actually interviewed teachers, we found that the data that the state has really doesn't tell the whole story, because yes, there are X amount of teachers who have left the profession, but we found 55% of the educators we interviewed had seriously considered leaving the profession in the past year. That's not reflected in the state data, but that's a huge problem that the legislature in partnership with K-12 schools and districts needs to address. And what MEPRI also found out is what's preventing those educators from leaving, and what would make them more excited to stay. And that's really informative to public policy. And that's what's the exciting thing about this research is not every one of those teachers can get down to Augusta, but through MEPRI's research, we're giving them voice and helping bring you the information, quote unquote, from the field or from the ground. So we completely support doing that with those on the ground, whether it's in schools or running small businesses in rural Maine.
So just a follow up. So is this membership basically teachers that are going to be jumping on board to do the data work? It sounds like it's not for the business, it's more for education. And I'm just kind of wondering how this all mixes for what we're trying to do.
So I think I understand what you're asking. So the membership of the steering committee is representatives of key stakeholder groups that are in this committee's area So workforce development, business attraction and retention. So I think the original, as well as the state economists, because another part of the steering committee's work is to say, what data already exists that we can learn from. So again, I use the example in the testimony. We're really interested in understanding how K-12 schools are using the, hundreds of millions of dollars of federal relief that's being made available to them. The DOE has those applications from schools. We want to analyze it because that can let us know what unmet needs exist so we can inform future public policy. So I was on the, the steering committee call when JC Holmes from the DOE said, we have all of these applications and they have great data in them. And MEPRI researchers could say, oh, we could use that to do X, Y, Z. So again, steering committee represents stakeholders, including the business community. The folks doing the actual research are economists and researchers. The university employs a number of professional economists. They're assisting the state economists. Folks in the state economist office are graduates of our programs. And so there are professional economists who are doing this work. They're not, they may also be faculty, they may also be teaching, but they are professionally trained economists.
Thank you.
Representative Collmore.
Thank you, Madam Chair. Good morning, Ms. Warren. How are you today? It's good to see you again.
Great to see you.
I was just curious. We had heard from the co-sponsor that the University of Maine, you match on MEPRI and you had intended to match on this. I was curious what the university system's commitment is for match for this bill should it pass.
It's a great question. As I said, the $250,000 kind of current appropriation was not where MEPRI started. And so I think we would be interested in, I know we would be interested in hearing from the committee, what's a reasonable scope? What work would you really like to see, given the bills that you have, on the docket? And, you and I have talked about one of your bills related to research and innovation, and you could imagine that's a very ripe area for us, the sort of analysis that MEPRI can do. And so, if those bills have been carried over for next session, you as a committee could look over those and see, what do we think, where do we think we really need some good information about what's happening in Maine and what's happening elsewhere to inform our work next session. And that could be a starting place for a work plan. I don't think this would be something that goes from 0 to 60 as MEPRI has built over the years. So I think I would like to hear from the committee, what the scope of work you would like to be is, and then we can put some potential numbers to that. And including what our in-kind contribution, could and should be. I will let the committee know that there is a bill in state and local government that I believe bounced between the two committees related to an economic impact related to the potential move to permanent Atlantic Standard Time, and it was referred to state and local government, but that's a sort of, there was bipartisan support for that legislation. And that's another area where an entity could, a university entity could do a study. The bill was for the university to do a study. And so there may be other projects in other committees that may also be relevant to this committee that would be part of that work plan as well. And I believe there is an appropriation being proposed to be attached to that individual study as well.
Thank you. Are there any further questions for Ms. Warren? Seeing none, thank you for your testimony this morning. Next up, we have Catherine Johnston.
Good morning, everyone. Senator Curry, Representative Roberts, distinguished members of the IDEA Committee. My name is Catherine Johnston, and I am Director of Research and Strategic Initiatives at Educate Maine, a business-led education advocacy organization. Thank you for the opportunity to testify in support of LD 1517. As you know, Educate Maine's mission is to ensure that Maine people are prepared to succeed in education and career, and that all Maine people reach their highest educational potential. As a member of the Maine Spark Coalition, we measure this by attainment, so the share of adult workers with a post-secondary degree or credential of value that is in demand by Maine employers. Maine's goal is to reach 60% by 2025. An essential piece of this puzzle is good, trusted information on Maine's workforce and training programs. The best policies and strategies for tackling these complex problems are informed by data. A small organization like ours relies on the work of several agencies for the best and most recent data on education and workforce outcomes. And despite our best efforts, there's still no central source of information for much of the needed data and analysis that our state's lawmakers need to make policy decisions. This bill directly addresses that problem. My written testimony goes over MEPRI, as you've heard a lot about today, so I'm going to skip over that. But I did want to reinforce something that Senator Daughtry said in her testimony, which is reinforcing that this is not just numbers that the Institute would be collecting, but rather analysis. And I know Ms. Warren spoke about MEPRI and teacher recruitment and retention. I would say if you do one thing after this hearing, please go to MEPRI's website and look at the teacher recruitment and retention report that was published in October. Even if you just look at the table of contents, I think that would give you a really good sense of the type of analysis and long-term research and the value add of pulling the data together in that way. I think as members of this committee, if this is something that goes through years from now, you'll look back and say, how did we ever do our jobs without this? So the same level of research and analysis in MEPRI would be a boon to the IDEA committee, as well as state agencies, businesses, nonprofits who are all working to increase educational attainment, career readiness, and adequate training for the jobs that are most in demand right here in Maine. Such an institute would build on the insightful data provided by the Center for Workforce Research and Information by providing broader context, projections, and analysis related to workforce issues. Maine would have the robust information necessary to track progress toward achieving the statewide economic development strategy, as well as the insights needed to inform complex public policy decisions related to our biggest asset, which is our people. Locating the Institute within our public university system is a wise decision. The university system is home to some of the best research happening in Maine. It is an underutilized source of research in demographic changes, workforce, economic development. It will also provide policymakers access to useful, relevant data that is unbiased and accessible to the public. It also reinforces the system's role as a leader in workforce and economic development and is in line with their responsibility to serve Maine people. So I urge you to vote in favor of LD 1517. Thank you for your consideration, and I am happy to answer any questions.
Thank you. Are there questions from the committee for Ms. Johnson? Seeing none, thank you for your testimony this morning.
Thank you.
Next up, we have Ben Lucas.
Hello, good morning.
Good morning.
Senator Curry, Representative Roberts, and members of the IDEA Committee. My name is Ben Lucas. I live in Portland, and I serve as the Executive Director of the Maine Jobs Council. The Maine Jobs Council is a new statewide, nonpartisan, member-driven advocacy organization that advances public policies to support the creation and preservation of foundational jobs in Maine. I am here today to testify in support of LD 1517. Maine has a serious workforce issue. We have an aging workforce and not enough young people staying or moving here. According to the Maine Center for Workforce Research and Information, the number of people in Maine over the age of 65 will increase by 113,000 in the next 5 years. A recent report by News Center Maine noted that our retiring workers will leave 158,000 open jobs in the same time period. Maine needs to act urgently to develop a long-term plan that helps our workforce and keeps jobs in Maine. We believe LD 1517 could be one step in addressing the pending workforce crisis. Creating the Maine Workforce Research, Development, and Student Achievement Institute would bring together a group of stakeholders, and this would facilitate input from companies that employ thousands of hardworking Mainers. We believe bringing together individuals from different industries and backgrounds will lead to better and more efficient future workforce development legislation. This is a key component to helping solve our workforce crisis. Having a comprehensive plan is critical for the economic future and success of our state. Policy solutions should be strategic, long range, driven by data, and connected to a long-term vision and plan for the future. We also believe this legislation would fall in line with Governor Mills's 10-year economic plan and the goal to attract 75,000 people to Maine's talent pool. We want to thank Senator Curry for bringing this legislation forward. The Maine Jobs Council would welcome any opportunity to be involved with the Institute. Thank you for allowing me the opportunity to testify today. I'm happy to answer any questions now, and I will be available for the work session.
Thank you. Are there questions from the committee for Mr. Lucas? Seeing none, thank you for your testimony this morning.
Thank you.
Ms. Breton, if you could bring in Mr. Norbert and Simon West, please. Oh, Senator Searway. You're on mute. You're muted, Senator.
Thank you, Madam Chair. I just was wondering for the work session if we could get maybe a list of, all workforce related programs that's supported by the state of Maine as far as how this all kind of plays into this. We kind of need to know what's already in place.
But we'll take any other requests after we finish the public hearing.
All right, thank you.
Yeah. Mr. Norbert, how are you?
Good morning. I'm very well, thank you still. And you? Representative Roberts, Senator Curry, distinguished members of the IDEA Committee, I'm Bill Norbert. I'm with the Finance Authority of Maine, as you know, and I'm here to support this bill. You can read my testimony. I won't repeat what's been said, other than to say we think this is a good idea. We would be pleased to be part of it, either as a formal member of the steering committee or as just an advisor or a resource for the committee. There's been a lot of talk about membership, and you folks do what you need to do. We just think the concept is important. You can have a program, you can have plans, but if you don't evaluate them periodically, then that's a problem, I think. So please consider us a resource, and I won't take up any more of your time. Thank you.
Thank you. Does the committee have questions for Mr. Norbert? Seeing none. That was quick. Thank you.
You're welcome.
Next up, we have Mr. West.
Good morning. Can everyone hear me all right?
Yes.
Fantastic. Senator Curry, Representative Roberts, and esteemed members of the Committee on Innovation, Development, Economic Advancement, and Business. Good morning, and I hope you all are well. My name is Simon West. I'm from Gardner, and I represent the Maine State Chamber of Commerce, a statewide business association made up of both large and small businesses, here to provide testimony in support of LD 1517, an act to establish the Maine Workforce Research Development and Student Achievement Institute. The State Chamber is a member of the Maine Spark Coalition and supports Maine's goal to have 60% of adults in the workforce hold a post-secondary degree or credential of value with demand by Maine employers by 2025. This level of education increases individual wages, increases worker skills and productivity, and shows employers that these individuals are motivated and capable of complex problem solving. The end result is a workforce that both generates and consumes greater quantities of goods and services. As we continue to discuss ways to face workforce shortages, we believe that the creation of a Maine Workforce Research, Development, and Student Achievement Institute will generate significant benefits for the work to improve future economic possibilities. The creation of this institute will increase the amount of relevant information available to policymakers in the areas of research and development, economic and workforce development, student debt, and a variety of other areas that impact our valuable stakeholders. The Maine State Chamber supports this bill's effort to provide economic advancement for Maine and its citizens. When discussing Maine's labor force issues, we often see two distinct categories. First, the size of the labor force, and second, the appropriateness of the available labor force's skills, abilities, and education. The information provided by the creation of this institute will create better understanding for the appropriate mix of education and skills for Maine's workforce, and will be able to reduce the cyclical excess and insufficiency of the numbers of different types of education skills in the workforce. With a greater level of education and a more appropriate mix of skills, the labor force will become more productive. It is often seen that increased productivity by a labor force leads to greater productivity by an economy. This is caused through greater number of goods and services produced and consumed, reduced cost per unit of output, and increased wages from cost savings and increased demand. Following these effects, the available labor force is likely to grow. Increased and meaningful investments in education, innovation, and other institutions that benefit from economic activity, coupled with rising wages, will make our state more attractive to workers from other states. This type of emphasis on labor education will propel us into a more robust economy characterized by rising wages, a growing labor force, and an infusion of new workers and employers looking to benefit from Maine's opportunities. I want to thank you for the opportunity to provide testimony, and I'm open to any questions.
Thank you. Does the committee have questions for Mr. West? Seeing none. Thank you for your testimony today.
Thank you.
Ms. Breton, I have Jessica La Liberté on the list. I don't see her in the attendees room.
She was there, but she sent me an email that she had to go to another committee.
Okay, so other than that, there's no one else.
No, I have nobody else signed up for this one.
Okay. Are there any requests from the committee for our analysts for the work session? Senator Searway.
Thank you, Madam Chair. Just repeating what I had requested about the workforce groups that are out there that we could find what's already happening. I'm just concerned because it seems like we need manufacturing, and that's what seems to be lacking in our communities. And if we get it just from educators, I don't see where we're going to get the business.
Senator Searway, I don't want to go into work session right now.
Yeah, okay, but that's what I'm just kind of trying to get to. So that, okay, as long as you understand it, what I'm trying to get to. Thank you.
Okay. Representative Collmore.
Just a copy of the amended bill that came out of committee last session.
Yes, I will. I actually have that material, and Mr. Seneff was the analyst during the 129th, and he and I are all set up to meet to discuss the bill history as well. So I'll get those materials out to you in advance of the work session.
Okay, no further requests. Having heard all testimony from those present, I am going to now close the public hearing on LD 1517. Hand the gavel back over to Senator Curry. Do we want to take a 5-minute break before we do the other two, or just go through them? Get a consensus from the committee? Does anybody want 5, or are we good to go? 5?
Let's do 5.
Okay, so 11:10 we'll come back on.
We're terrible at the 5-minute break, aren't we?
Representative Collmore texted me. I just got it saying I wasn't on mute like the last 25 minutes or so, and I wasn't paying attention. And I was really nervous that I had said something, or I'm also tired today, so I feel like I've been yawning a lot. And it's not you, it's me.
Was it in this committee that we got the compliment that we were a very friendly, chatty committee?
Yes.
Because the panelists can hear us even when we're not live and we don't see them on the screen.
Yeah.
Yeah.
We do have to remind ourselves of that every once in a while, but we are live on the screen now. So, well, welcome back, everybody. It's always a good experience to have to present something and then stay quiet and just listen. So it's always
the ultimate test in
always
patience, right?
Yeah, exactly, and self-control.
Exactly.
So, well, all right. Let's open up the work session for LD 1551, an act to ban the sale of cosmetics that have been tested on animals. And Ms. Breton is, I see that Representative Dudera is in the attendee list. Welcome, Representative Dudera.
Welcome. Hi, everybody. How are you? I got a crying little grandson in the background, so I'm moving to another room. I'm pleased.
You have the committee's attention. Please begin.
Pleased to be with you here for the public hearing for LD 1551, an act to ban the sale of cosmetics that have been tested on animals. Good afternoon to Senator Curry and Representative Roberts and all your other beautiful smiling faces. I'm Representative Vicky Dudera, and I represent House District 94, the towns of Camden, Islesboro, and Rockport. I'm here today to introduce the bill I just mentioned. Testing products such as lotions, shampoos, and makeup on rabbits, guinea pigs, mice, and rats is cruel and outdated. In these tests, substances are forced down the animals' throats, dripped into their eyes, or smeared onto their skin before they are killed. Not only is this practice inhumane, but it's unnecessary. Cosmetics companies have the ability to use existing ingredients with a history of safe use, or if they choose to use new ingredients, they can choose from a wide range of new non-animal test methods. These new methods do not only spare animal lives, but they also represent the best that science has to offer and can provide more data, more relevant to human exposure, ensuring that cosmetics are safe. It's important to know that there are no animal testing requirements for cosmetics in the US, and many companies already use non-animal testing. If that's the case, why have 4 states, California, Nevada, Illinois, and just a few weeks ago, Virginia, passed laws similar to the one before you? Why is a comparable bill on the governor's desk in Maryland and soon to be in Hawaii, with Rhode Island, New Jersey, and New York also exploring this ban? Why are consumers and cosmetic companies, including many in Maine, voicing their support for our state to join the global push to ban animal-tested cosmetics? The answer is China, which requires that cosmetics sold in its large and lucrative market undergo testing on animals by Chinese regulators. Passing laws such as LD 1551 will help persuade the US government to join Europe, India, and other countries in putting in place a nationwide ban that will in turn help China end its animal testing requirement. Federal legislation is supported by the Personal Care Products Council, the leading national trade association representing 90% of the US cosmetics industry. LD 1551 was carefully drafted to mirror the provisions in this federal legislation. LD 5051 will prohibit a manufacturer from selling a cosmetic product that has been tested on animals in the state of Maine after November 1st, 2021. And I want to correct the way I just said that. It will prohibit a manufacturer from selling a cosmetic product that has been tested on animals after November 1st, 2021. The bill contains some limited exemptions that address the realities of the global cosmetics marketplace. The first exemption is to address requirements in place in other countries where manufacturers may need to conduct new animal tests to sell cosmetics. The second exemption is for testing done on products or ingredients that are classified as drugs by the Federal Food, Drug, and Cosmetic Act, such as sunscreen and deodorants. The third is to address testing that is done on ingredients that are being tested for non-cosmetic purposes. Most ingredients are not developed just for use in cosmetics, and therefore animal testing may be done to meet other legal requirements, such as for chemical registration laws. However, LD 1551 prevents a cosmetics manufacturer from using this new animal test data unless the ingredient was in use in a non-cosmetic product for at least 12 months and there is no non-animal test that could have been used instead. The fourth exemption allows for new animal testing if an ingredient poses a risk of causing a human health problem and there is no non-animal test or alternative ingredient available. So I first learned about this issue in February 2020 in the Maine Sunday Telegram. I read that a growing number of US states were considering a ban on the sale or import of animal tested cosmetics, and I knew that Maine had to be a part of it. We have a proud tradition in the Pine Tree State of conservation, of stewardship of our wildlife, of animal rescue centers that bring pets from kill shelters in all other parts of the country and unite them here with Mainers who have waited patiently on long lists. We're a state that cares for animals, so much so that we have to put out signs this time of year so that well-meaning people don't rescue what they perceive as abandoned baby seals or fawns. By passing LD 1551, Maine would align with the other states and countries who recognize that it's cruel and unnecessary to have animals suffer for the sake of shampoo. Please vote to pass LD 1551 so that our state can help put an end to this outdated practice. Thank you. I'm happy to answer any questions.
Thank you, Representative Dudera. The chair recognizes Representative Collmore.
Thank you, Mr. Chair, and thank you, Representative Dudera, for your testimony today. I think the number one question I have in reviewing this bill and hearing your testimony is how can the state impact companies that are on a level of being across the country? So let's take your major stores like Walmart's and Target. And how can we enforce something that isn't enforced federally and not impact these companies, not impact people's ability to get products that they would normally get at these companies, and stopping them from ordering online from another state where we would then lose the revenue in here?
Mm-hmm. Well, it's a good question. And we do have a couple of people Oh, gosh, I'm sorry. Hold on 1 second. Okay, can you maybe take him? It's a good question. And I think that, for one thing, the move is really to put pressure on the US. If states keep signing on to this, then the US will sign on to it. And then we have more clout with countries who right now are not doing this, like China. But that's why the bill has so many exemptions in it right now for that reality that, the number one exemption there, requirements in place in other countries where manufacturers may need to conduct new animal tests to sell cosmetics, that's China. So right now we're not saying that China is exempted. It's not quite a thorough 100% ban right now, but it's a move to take this movement kind of across the country so that then the US is going to do it and we have more clout. And it doesn't apply to products that are currently on the market either. So it only applies for new animal testing on new products. So things that are already
Follow up, Mr. Chair.
Go ahead.
Thank you. Okay, so that was another area where I wasn't quite clear. So you're looking to do a ban on new products, not products that are already being used and sold.
Right, it's new, it's testing on new products, exactly. They
Okay.
don't have to test the
All right.
products that are already out there.
Okay, and so how would this, going along those lines of the big stores that are across the nation, I'm thinking about also our mailing retailers like Amazon. How would they be affected by something like this? Or have we seen results in other states that have already taken these steps and how that's affected people ordering from Amazon, for example?
Gotcha. I'm going to let Ms. Hansberry, who's coming after me, and she's from the Humane Society, I'm going to let her answer that because I honestly don't know. And that's a great question.
Okay, thank you.
Chair recognizes Representative Roberts.
Thank you, Mr. Chair. Hi, Representative Dudera, how are you?
Very good, I think.
So I read your bill, and I'm sure you probably know my son did already. And we are a household of zero animal tested cosmetics. Okay, so, and maybe Kate, Ms. Hansberry can help flush this out. So, like I purchase all my makeup at Ulta. I buy their cruelty free. They have products there that are not made in China. And this might be a question for Ms. Olson too. So where does it fall if I'm not going to mention, I'm not going to call out any brands, decides to come out with a new color? Is that a new product? And we then hamstringing these big box retailers. I don't know how easy they're going to be to regulate. I can see isolating out brands, but I think new products might need to be flushed out a little bit.
Mm-hmm.
Do you agree?
I understand it. The retailers aren't the ones that are impacted. It's the manufacturers.
Okay.
And we do, there is some cosmetic manufacturing going on in Maine. And, the Humane Society did reach out to them and they were supportive of this. And, perhaps you're going to hear from some of them today. I saw quite a bit of written testimony in there. But, that is really who ends up being impacted on this is the manufacturers.
Okay. Just one follow-up, Mr. Chair. Do you know, for you or for Ms. Olson, if you don't know off the top of your head, other states that have enacted something like this?
Yeah, I mentioned, and it's quite a few and more coming all the time. Let me just find that. So California, Nevada, and Illinois have it in place. And just a few weeks ago, Virginia enacted it and the governor signed it. And it's on the governor's desk in Maryland and Hawaii. And then Rhode Island, New Jersey, and New York also are in the same spot that we're in with, legislative hearings and things like that. So it's part of a movement, it's a cruelty-free cosmetic movement that, we feel like as more states pass this, then we are putting pressure on the Biden administration to pass it. And then we can really begin to have China stand up and say, and they are starting to move toward it also, but they're a huge manufacturing area, and they, if they think the US, which is also a large market, is not going to buy their products, then it will impact what they're doing.
Okay, thank you.
And the companies are behind this too. This is the thing. That's why I mentioned, the Personal Care Products Council, which is the leading trade association representing 90% of the cosmetics industry. They want this. They are behind it. So.
Okay, thank you. If Ms. Olson could give us maybe a side-by-side of a couple of those states and how the legislation mimics to see if it's in line, that would be helpful. Thank you.
Sure, you could probably do that for the work session. Her name is Ms. Hansberry, by the way.
No, I'm talking about our analyst.
Oh, your analyst. I'm sorry. Gotcha.
So thank you. Chair recognizes Senator Searway.
Thank you, Mr. Chair. I was just wondering about how this, I'm thinking, I haven't seen too many situations where they use animals for testing here in Maine, but I think of Jackson Laboratories for cancer and whatever. And I've also, heard of people losing their hair from some cosmetics or getting possibly even cancer. So if you do this, would that affect like Jackson Laboratory? And have you looked into that or anything? You have? So
yeah, Jackson Labs, you're right. You're correct in saying that Jackson Labs does use animals. They use mice, but they are not producing cosmetics. So this only applies to the cosmetics and not, the testing that they're doing to make new drugs.
Okay, thank you. I didn't know how we're gonna test with GeoPets or, no, just kidding.
Well, they actually, I didn't want to put it all in my testing, but they have material that they've made that, that is very much closer actually than mice or rats or guinea pigs are to mimicking, human conditions and human tissue. And I forget what it's called, but that's much better to use, really. And then the fact is that a lot of times when they're making new products, they're using ingredients that have already been tested. So they don't need to retest those ingredients. It's only if they're using new ingredients. And there are ways that don't involve, really what basically is like torture of these animals.
Yeah, thank you.
Representative Dodera, can you say it's accurate that, I remember these battles from 30 years ago and 35 years ago when the companies were dead set against this, but it seems like we're in a very different place based on the science and is that accurate? Is that your understanding of where the cosmetic industry has maybe been forced to move to, or has the sciences allowed them to move to?
Yes, Senator Curry, I think it's all of that. And I also think it becomes a branding thing for them because so many consumers now, want cruelty-free cosmetics. So I agree with you. We're in a different place. And that's why you do see their trade association backing this and actually actively encouraging it.
Thank you. Chair recognizes Representative Pepworth.
Thank you, Mr. Chair. Thank you, Representative Dodera, for being here today. I have two questions. One is, you brought this bill forward. Obviously, you're a caring person. I don't understand why you have not treated your grandson in a caring manner. So that's the first question I have for you. The second is, I'm curious with the exceptions. I understand that one of the long range goals of this bill is to put pressure on countries such as China, who are not as on board with this as some of us might be. But with all the exceptions, what would you anticipate the actual effect here in Maine in the next couple of years would be?
I will say that my grandson is off with his grandfather. So that's a good thing. I didn't lock him in the pantry or anything like that. He's, I think the effect is going to be very minimal. I feel like here in Maine, it's largely symbolic. I think that, in Maine, we do have we do value, our animals, and we're a state that, really cares about it. So I think in Maine, in terms of our manufacturing here of cosmetics, it's really not going to impact them. So, but I think, they want to be on board with this because they're taking those extra steps, not to do this. And and ethically, they think it's the right way to go. And I do too.
I muted myself to keep when I was laughing. So Chair recognizes Representative Geiger.
Thank you, Chair Curry. Thank you, Representative Dudara, for presenting this. So do you see this bill as sort of the first wave, sort of establishing a sort of a vision, really, for where we can go over time? And then as other states pass it, as organizations see it, and given that the research has already led to alternatives, do you see this as sort of something you could come back to and strengthen as time goes on? Is that your hope, that this is sort of establishing a foundation from which to go forward?
Yeah, I think that's a great way to say it, Representative Geiger. And I mean, or perhaps what could happen is the federal law could come into play, and then, it's not going to be needed. But yeah, this has got a number of exemptions that, that weaken it for sure. But, they're addressing the realities of what things are today. And nevertheless, even though this has got some exemptions built into it, it is going to make a statement. It is going to help. And the more states that do this, the more we can draw attention, to the issue and put more pressure on our own country to do it, which will then put pressure on other countries. So, and this is Europe has already got it, India, a number of other places. So.
Seeing no other questions. Thank you very much, Representative Dudara. And Ms. Breton, if you could bring in Ms. Katie Hansberry.
Good morning.
Welcome. You have our attention.
Thank you very much, Senator Curry. This is my first time presenting before the IDEA Committee, so it's very nice to see some new and different faces on my Zoom world today. So very nice to see you all. Senator Curry, Representative Roberts, and members of the Committee on Innovation, Development, Economic Advancement, and Business. My name is Katie Hansberry, and I am the Maine State Director for the Humane Society of the United States. On behalf of the Humane Society of the United States and our Maine supporters, thank you for the opportunity to submit testimony sharing our strong support for LD 1551. I also want to thank Representative Dudara for sponsoring the bill, and all of the co-sponsors for their support, including IDEA Committee member Representative Pebworth. So I'm going to diverge from my written testimony to hopefully, I tried to listen carefully and make some notes about the questions that were answered. So I'm going to try and go through and address those. And so I might be jumping around a little bit. And it won't be as eloquent as if I were reading from my prepared testimony, so bear with me. So one of the things that I want to make clear, and that hopefully will help, is that this language was carefully crafted to limit liability to the manufacturers. So, and with respect to the questions regarding enforcement, this isn't a law that requires any sort of proactive enforcement. It doesn't require any sort of new inspections or things like that to happen. Enforcement is complaint driven. So there would be, a whistleblower or someone that is aware of there being a violation, and that complaint would be what would result in there being an enforcement action. In the 3 states, California, Nevada, and Illinois, those 3 states, I believe they all went into effect January 1st of 2020. Thus far, there have not been any enforcement actions in those states. And the other component regarding enforcement that Representative Dudera did touch on, this is about addressing new animal testing on cosmetics and their ingredients going forward. So anything that is currently on store shelves, currently available, that's not going to be impacted. It's not going to be, taken off the shelves or causing any issues. And as she also pointed out, industry is definitely on board with this. She mentioned the Personal Care Products Council, and we do have a number of retailers and manufacturers in Maine. You did receive letters of support from 3, including Salty Girl Beauty, One Earth Natural Food Store, and Lush. Additionally, with the federal legislation that has been referenced, there are 7 companies headquartered in Maine, and those companies are listed in my written testimony that are all on board and supporting the federal legislation upon which LD 1551 is mirrored. So we have that support. And another reason, what this will do is it incentivizes companies to continue the trend of replacing animal tests with better, more human relevant science. And it's also providing industry with something that's really important to them, and that's regulatory alignment and uniformity. And what this will do is, as more and more states pass this law, more countries, there are currently 40 countries that have passed laws to address this issue. That also provides the industry with some more clout to have changes made elsewhere to continue with that regulatory alignment. And that is something that they very much are looking for. And so much of the work that we do at the Humane Society of the United States, and this is a great example of it, yes, there are exemptions. And what we do is we work with stakeholders, on all sides of an issue, and we find common ground, and we find out a way that we can move forward and make change. And this bill will create change. It does send a message. And as I mentioned, it will do that incentivizing and hopefully help us, get things passed at the federal level and with other states. I am happy to provide a little more information about what those alternatives are to animal testing, if folks would like to hear a little bit more about that. And I think
our time is just about up. So if you could wrap up in the next couple
Absolutely.
sentences.
Thank you for bearing with me as I jumped around to try and address those questions. Another thing, as it was pointed out, I think this will also give, Mainers, confidence in what they are purchasing with respect to especially new products going forward, that there's not new animal testing that's going on. And Maine is consistently a leader on many animal welfare issues, and in keeping with this proud tradition, and to also stay competitive and innovative, we ask that you vote ought to pass on LD 1551 and make Maine the next state to address the unnecessary cruelty of cosmetics testing on animals. Thank you for your consideration of this important issue, and I'm happy to answer any of your questions. Hopefully I've already done a little bit of that. I'll be available for the work session, and I also have a colleague that specializes in this issue, and she'll be available for the work session as well if there's additional questions that I'm not able to answer for you today.
Thank you. Chair recognizes Representative Austin.
Thank you, Mr. Chair, and thank you, Ms. Hansberry. You mentioned, I don't have your testimony right in front of me printed right now, but would it be all right for you to share the 7 companies? That's one question. Second question is, are the companies that are here in Maine, are they more of a manufacturing site? Are they national brand? Or maybe you could just put just a little meat around those bones for me.
Sure. Yep. So there's a little bit of a mix. And so the 3 entities that provided letters of support that you'll find in the written testimony are Salty Girl Beauty. And they, again, I don't want to speak for them, but I do believe that they manufacture their own products, and they sell their own product cosmetic line. And then there is One Earth Natural Food Store. and so Salty Girl Beauty, they are located in Kennebunk, and One Earth Natural Food Store is in Shapley. I believe that they are a retailer. And then there's also Lush Cosmetics. They have a retail location here in the state of Maine. They do also produce cosmetics, but they have a retail location here in the state of Maine. The other ones are Lotus Garden Botanicals in Biddeford, Maine Hempworks in Naples, True North Beauty in Milo, First Impact New York in New Gloucester, and Green Tech USA Inc. in Yarmouth. And I think it's a little bit of a mix. And I can get a little more information about those entities for the work session. I don't have it at my fingertips.
If I may, Mr. Chair.
Certainly.
That's great information. And I do recall you did mention the Salty Girl. Maybe that's what triggered me as to asking if they were the actual, if they create new products or just manufacture for, like I said, a national line. Could you give me the New Gloucester one again? That's really, obviously, that's very close to Gray, and I'm fascinated. Those contacts would be great for us to have again, just because if we ever have an opportunity to reach out and just talk with them, not necessarily regarding this, but their issues at large. So.
Sure. And I will mention, so First Impact New York is the business that is located in New Gloucester. And then there was Green Tech USA Incorporated in Yarmouth. And those two entities are two of the, so let's see. So for the support for the federal legislation, so that was, we worked very closely with the Personal Care Products Council, and they have about 600 member companies. So those two that I just mentioned, their support for the federal legislation is through their membership with the Personal Care Products Council. And then the other ones that I mentioned are part of the 335 individual companies that have kind of signed on separately and individually in support of that federal bill.
Thank you so much.
Ms. Hansberry, could you, are there some national brands that that have signed on individually to the federal legislation that we would know?
So I am sure that I can get you more information right off the top of my head. I didn't prepare, but I'm sure there definitely are, especially with the trade entity, the National Trade Organization being on board. And I'm happy, I can actually provide links. We do have documents that contain all of the organizations that are supporting.
Great, thank you very much.
You're very welcome.
Are there any other questions for Ms. Is it Hansberry, correct?
It's Hansberry. Thank you,
Hansberry.
Senator Curry. Yes.
Seeing no other questions, thank you very much for your testimony today.
Thank you so much for your consideration. Nice to see everyone.
Ms. Breton, is there anyone else here to give testimony on this bill?
Yes, Mr. Marks is here.
Okay, if you could promote him into the panelist. Welcome, Mr. Marks.
Thank
have
you.
the committee's
Sorry for that
attention.
delay. Senator Curry, Representative Roberts, and members of the IDEA Committee. My name is Jeff Marks. I'm from Portland. I'm testifying in support of LD 1551. I want to thank Representative Dudera for sponsoring this bill. She represents the district where my employer is based, Acadia Center in Rockport, but I'm testifying today on a personal basis and not on behalf of any organization. I took a career break a few years ago to volunteer with an extreme animal rescue team. That was in 2018. Our entire mission was to alleviate suffering, combat cruelty, rescue dogs, cats, and all types of critters that were exposed to dog fighting and cockfighting, natural disaster areas, dog meat markets, or other types of abandonment, neglect, trauma, and abuses. During my volunteer work, I watched dogs starved and brutalized before throwing them into a dirt pit to tear each other apart, while people cheered, drank, and gambled. In some cases, and sorry to get so graphic here, but sometimes the still living dogs were thrown into piles with the dead ones. It's hard to talk about, but I saw live cats, dogs, rabbits, and other defenseless animals crammed into cages, left out into 100-degree humidity at markets to sell for all types of purposes, whether food, fighting, or other excruciating lives or deaths that they had in front of them. So I'm happy to report I'm back in Maine, but also a little disappointed that there are practices that are sanctioned, cruel, and unnecessary practices like animal testing for cosmetics. People are trying to look better or feel younger, and as Representative Dudera mentioned in her opening, there are animals that have substances forced down their throats, dripped into their eyes, or applied to their skin, often for weeks or months before they're killed. These practices are legal and allowed, even though those same companies can produce effective products using existing ingredients that are not so harmful or so painful for these animals. So I do see cosmetic testing on animals as a type of abuse. It's different from what I saw in my volunteer work in developing countries, but it is being done in corporate labs that are away from the eyes of the public. Money is still being exchanged, but instead of the poor farmers that I came across in some of these countries who were drinking and wagering their hard-earned money on whether their chicken or dog lives or dies, there are companies that are making millions off the anguish and pain of these animals. I am heartened today to hear from Katie and Representative Dudera and others that the industry is moving more and more toward anti-cruelty cosmetic testing. So that's good to hear, and that it's such a sizable part of the industry is definitely a good sign that we're moving in the right direction. But really, this type of cruel and inhumane animal abuse and cruelty should not be happening here in this country, and we shouldn't be paying for it. So I hope you support this bill as a good first step toward making sure that these cosmetics are not sold in the future. Thank you.
Thank you very much. Are there any questions for Mr. Marks? Seeing none, thank you very much for your testimony.
Thanks.
Ms. Breton, is there anyone else here within the attendee list here to give testimony on LD 1551? Ms. Breton? Looking in the attendee list, I don't see anyone else here. So we will close the public hearing on LD 1551 and move on to our last bill for this morning, which is LD 1309. So we'll now open up the public hearing on LD 1309, an act to address systemic racism and improve economic prosperity. Representative Ms. Breton, can you promote Representative Talbot Ross to the panelist? Before we get started, Representative Hassenfuss, you have a question?
Yes, thank you, Mr. Chair. I was just wondering if Ms. Olson can see if there's any issues regarding the interstate commerce clause, any constitutional issues there with the bill we just discussed.
Thank you very much. I did forget to ask for any request of Ms. Olson. Is there any other request? Great. Thank you very much, Representative Hassenfuss. So, welcome, Welcome, Representative Ross. The floor is yours. You have the committee's attention.
Thank you kindly. Well, Senator Curry, Representative Roberts, and distinguished members of the Joint Standing Committee on Innovation, Development, Economic Advancement, and Business. My name is Rachel Talbot Ross, and I represent House District 40, which comprises the neighborhoods on the peninsula of Portland. I want to thank you for the opportunity to come before you today to present LD 1309, an act to address systemic racism and improve economic prosperity. As a state, we are doing a lot of important forward-looking work to ensure a prosperous economic future for all Mainers. The Governor's Economic Recovery Committee, the Climate Council, and the 10-year Economic Development Plan are all part of these efforts. As lawmakers, I know our deliberations around federal COVID-19 relief and the American Rescue Plan Act funds will also be grounded in both medium and long-term efforts to build and sustain a more vibrant economy. I introduce LD 1309 because I believe it's so important that marginalized and historically disadvantaged communities are full partners in those plans. Too often, even despite the best of intentions, these efforts may include 1 or 2 seats at the table for people from diverse backgrounds, but fail to adequately address the underlying inequities that persist in our economy. Often, when we think of racism, we think of it as an individual phenomenon. But the most profound and pervasive forms of racism is systemic or structural. What do these terms mean? Well, systemic racism refers to the policies, regulations, and the norms of our institutions that create and perpetuate disparate outcomes for Black, Indigenous, and people of color. To address these disparities, these inequities, including the most significant, which is economic inequity, we have to address the structural and systemic racism that creates and perpetuates it. I want to be clear. Addressing these inequities does not just benefit the historically disadvantaged communities. It will benefit all Mainers. Policy experts working to address the racial wealth gap in Minnesota, for example, have estimated a loss of $287 billion to the state economy due to racial disparities, including the wage gap. Imagine what addressing racial inequities would mean for Maine's economy as a whole. In fact, the Maine Center for Economic Policy estimates that closing the wage gap alone for Black, Indigenous, and Mainers of color would generate a total of $519 million in additional economic activity, enough to support nearly 4,100 jobs. This is an incredible amount of unrealized prosperity and untapped potential. Again, imagine how different our communities, our state could look if we finally recognized this and took action. What should this action look like? Well, to return to the example of Minnesota, policy experts have developed a policy blueprint from which we can draw. The so-called Minnesota Solution, developed by the Alana Community Brain Trust, includes 5 key elements I believe will be fundamental to any successful effort here as well. Number 1, recognizing and centering the African, Latino, Asian, and Native American communities, known as Alana, as one of our state's most valuable assets. Number 2, putting people at the core of our economic development efforts, which means measuring and assessing our efforts by how effective they are at increasing prosperity for all and closing the wealth gap. Number 3, operating policies and programs with cultural intelligence, which means understanding our diverse communities so we can engage them effectively and ensure accessibility. Number 4, empowering individuals to effectively engage with their environments and networks so they can achieve and sustain prosperity. And 5, initiating a series of sustained investments in the Alana economic development infrastructure. As we examine the opportunities and challenges before us, we must ensure that all Mainers can participate fully and achieve their potential. I look forward to working with the committee and stakeholders to ensure that we are viewing equity as a prerequisite for all of our economic development efforts. And I want to thank you for your time here this morning.
Thank you, Representative Talbot Ross. And the chair recognizes Representative Collmore.
Thank you, Mr. Chair, and thank you, Representative Talbot Ross, for being here today. I think one of the questions, well, I have two questions. First of all, if I'm wondering if you've come up with an amendment, considering that what we have in front of us is a concept draft, so we can see clear language.
Thank you, Representative.
Okay, great. No, go ahead.
No, I thank you for the question, and we are still preparing that amendment, and we'll have it to the committee shortly.
Okay, great. And my follow-up with that, when you're considering amendment language, I'm wondering if you've considered that. I think one of my concerns with, at least with the title, again, given that we don't have a lot of language behind it, is that it implies that the only reason that there's separation in wealth is because of race. And having been somebody who's had to pull myself up from the low class, and I'm sure you can see I'm very pale. And I have a child. I was low income. I was separated, and for many reasons, from my now ex-husband, and had to live in low income housing. I worked 4 jobs to try to support my son and make sure he could go to a good daycare so that he could have good early childhood learning experiences. And I want to make sure that when we're considering legislation like this, it's not only because of race, and that it's because of economic status. We are a low socioeconomic state, unfortunately, and I'm hoping that your bill draft language would include that. Is that something you're considering?
Well, I thank you for sharing that personal information this morning, Representative. And I do understand the generational poverty that has been part of Maine's history for its white communities. I myself am a 9th generation Mainer of African descent, so I'm well grounded in what generational poverty has looked like across our state, and am absolutely committed to trying to eradicate that poverty. But this bill is not about that. This bill is about addressing systemic racism. And the reason I say that respectfully, Representative, is because historically, the racial wealth and wage gaps cannot be denied. In other words, we have not seen any improvements, such as the example that you gave personally, that happen across all of the communities that identify as Black, Indigenous, or people of color in our state. So we need specific, targeted strategies and tools to bring those communities, those whole communities, just up to reach parity with our fellow white Mainers. If we do not have specific strategies aimed at tackling this in those communities, then we will never catch up. So while I am committed to and will work with you and others to try to address generational poverty by white Mainers, this bill is not that vehicle.
Are there other questions for Representative Talbot Ross? Chair recognizes Representative Geiger.
Thank you, Chair Carey, and thank you, Representative Talbot Ross, for being here today. I was in a former position as clinical director for all the federally qualified health centers. And one of the things I did was write a lot of grants. And one of those grants involved Indigenous communities up in Eastport. And as part of that grant request, we received information about things like life expectancy, domestic violence, loss to suicide, loss to homicide, all things that were indicative of major adverse childhood events or severe trauma to an entire community of people. How do you see your bill as it gets fleshed out, sort of addressing from the very start the kind of trauma that young children in Indigenous communities experience?
Well, I want to thank you for that question, Representative. One of the key elements of this bill and the concept that we must as a state start to understand is that we cannot eradicate systemic racism. We cannot eradicate the racial disparities and the disparities that are present for our Indigenous nations unless we invest in these communities so that they are self-determinant in those outcomes that you mentioned. We can't build partnerships with marginalized communities if they are always in a subordinate position. So eradicating those disparities is not just the obligation of the state or the government or any other entity or institution before it is the inherent right of those communities to try to solve it themselves. I hope I'm making it clear. We need self-determinant communities of color and Indigenous communities in the state in order to start to eradicate some of those negative outcomes. And unless we start investing in these communities directly and coming up with specific strategies, such as the model of the Minnesota solution, I'm not hopeful that we will see any changes in what you have described. I hope I've answered your question as thoroughly as possible.
Yes, thank you so much.
Chair recognizes Representative Roberts.
Thank you, Mr. Chair. Hello, Representative Talbot Ross. How are you?
Good. How are you? Thank you.
Good. So kind of just along the lines of not having text before us yet, to get an idea, as you're aware, I had the privilege of helping last session as being part of the working group with the Permanent Commission and kind of analyzing, all the bills and the great amount of work that was done there. Is this bill coming based off of that work? Is that what we're seeing there? Because I know that a lot of work was put in and then a lot of things just died and we never got to see them to fruition. So that's what I'm wondering, is this coming from all that work that was done, what we're going to see before us?
Well, thank you so much, Representative, for mentioning the Permanent Commission on the Status of Racial, Indigenous, and Maine tribal populations. You are right that in doing the work last summer, for several months actually, the Permanent Commission combed through about 454 bills that were remaining in the 129th and through a racial equity lens, and was able to determine that only 20 bills, this goes back to the earlier question by Representative Collmore, only 20 bills out of 454 would actually move the needle in eradicating racial disparities. 20 out of 454. So the answer that I gave to the good representative was, if only 20 bills out of 454 will actually have a demonstrable impact on eradicating racial disparities, 20 bills out of 454, then we must pass bills like this one before you if we're going to make a dent in that. If we don't care, then we don't pass it. If we care about all Mainers enjoying an economic prosperity and access to opportunity, then this bill is critical in making that happen. And the work that the Permanent Commission did last year, rightfully referenced by Representative Roberts, is a great start in trying to do so. So this foundationally, Representative, comes out of that work, and I appreciate you mentioning it.
Thank you.
Seeing no other questions. Thank you very much, Representative Talbot Ross.
Thank you all. Yep, enjoy the rest of your day.
Ms. Breton, is there anyone in the attendee list that's here to speak on this bill?
I have nobody else signed up for this bill.
Okay. Having heard all the public testimony, we will close the public hearing on this bill, and I've lost the number. Can Representative Roberts, what's the bill number? 1309?
1309, yep.
1309, great. So I'm going to recognize that it is, so we will close public hearing, the public hearing on LD 1309. Is there any request of Ms. Olson? I'm sure we'll be waiting on an amendment that would fill in the concept, fill in the concept draft. Is there any other requests for Ms. Olson? The only one I have, Representative Talbot Ross referenced Minnesota and their legislation. So if the amendment relates to that, then I would look for some background information on that as well. And with that, it is 12:06, and we have. I'm going to propose that we put we take a break for lunch, and we come back at 1. And to begin LD 110. Representative Roberts, would that work? I'm just looking at our schedule.
Yes, I thought we were going to do 1:30 and have.
Am I off on calendar?
I don't know. We had some conversations about doing caucuses at 1.
Oh, that's right. That's right.
1:30.
So we will. I forgot about caucus time. So we will come back at 1:30. And I think we had made that adjustment as well. So with that, we will return at 1:30 for our afternoon session.
Would you like me to let the sponsor of 110 know that we're back at 1:30?
Representative Roberts, did you do that already?
I will let her know. She's not in the waiting room, so.
Okay.
She was there, but she's not anymore, that's all.
Okay.
Thank you very much. Yes,
I'll
Ms.
let her
Breton,
know.
if you could do that, go ahead and do that.
And if all of you would check your legislative emails, we're waiting on bills to get on your supplements for tomorrow, but on divided reports, we need everybody to vote.
So would that have email come directly on your name? I think it did.
No, it come under Casey Milligan.
So check for an email from Casey Milligan. Please make sure you've responded. So again, the reminder, divided reports need all of us to say agreed or approved. So with that, any questions? Representative Geiger?
Just a question to Ms. Breton. I received one and answered it. Are there others out there that I should be looking for from Carrie Mulligan?
I think our committee only has one. If you're on other committees, you could get others.
Thank you.
It's Casey Milligan.
Yeah.
And you had a question also, Representative Pebworth?
Do we have bill analysis for 210 and 1168? Are they with our committee materials?
They will be shortly. I'll be sending them out at lunch.
And so with that, we'll break. So we'll see each other at 1:30. We'll wait a few moments to see if our colleagues arrive. We'll wait a few moments for our colleagues to arrive.
Did you want to touch base with them, Mr. Chair?
Yeah, I'll give them a phone call. They might be still in caucus.
Okay.
Welcome back, everybody. We will begin our afternoon session. I'm Senator Chip Curry, and I'll be presiding over this work session of the Joint Standing Committee on Innovation, Development, Economic Advancement, and Business. The purpose of this meeting is for the committee to receive information from staff and others in order for members to consider the legislative proposals before them and make recommendations or reports to the legislature. Only committee members, the committee analysts, and those specifically invited to attend will be participating in the work session using Zoom. For members of the public wishing to observe this meeting, it is being live streamed on the committee's YouTube channel and is also being recorded for viewing after this meeting is concluded. Let's see, you can find, we are broadcasting the audio. We are also broadcasting the audio of this meeting on the legislature's website, www.legislature.maine.gov. As always, if you are in the panelist room, you can be seen and heard. Please manage your audio recording appropriately. This is a public meeting. I'll remind everyone to keep chat to just technical issues. If you are having technical issues, please reach out to our committee clerk, Jody Breton, and she can you can reach her by emailing idea@legislature.maine.gov. At this point, I'll ask the committee members to introduce themselves. Representative Geiger, can you start us off? This will make a lot more sense when we're all sitting in a horseshoe and we just go around, but we'll do it this way.
Good afternoon. My name is Valerie Geiger. I'm representative for District 93, Rockland and Owl's Head.
I'm Sarah Pebworth. I represent House District 133 in the Blue Hill Peninsula. That includes Brooksville, Brooklyn, Blue Hill, Castine, Sedgwick, and Surrey.
Good afternoon. My name is Amanda Collmore. I represent House District 106, Pittsfield, Clinton, and Detroit.
Good afternoon. I'm Senator Scott Searway, and I represent District 16, which covers Waterville, Winslow, Fairfield, Benton, Albion, Clinton, and Unity Township.
Good afternoon, Maine. I'm sitting here in Gray. Beautiful afternoon. I represent probably 3/4 of Gray. I have portions of the lovely towns of Casco and Raymond, and I have all of Fry Island.
Representative Tavis Hassenfuss, House District 81, Winthrop, Reedfield, North Monmouth.
Representative Kyle Bailey, House District 27, part of Gorham and a small part of North Scarborough.
I'm Representative Tiffany Roberts, House Chair, representing House District 6, which is the majority of North and South Berwick.
And good afternoon. And again, I am Senator Chip Curry, and I represent the 26 rural, coastal, and island communities of Waldo County, which is Senate District 11. So let's see, a couple other announcements for the go to the order. Ms. Breton will be managing the attendee list. She is our committee clerk, and Ms. Rachel Olson is our legislative analyst and will be providing the bill analysis, which we'll get to in just a moment. Members will speak with the leave of the chair. Materials will be provided electronically for this meeting. And so if people are following along, you can get to those materials by going to our committee's website, which is a link right off of the legislature.maine.gov website, clicking on committee materials, and then committee materials by LD, and you'll see the order that we're addressing those bills on the schedule today is LD 110, LD 210, LD 1168, and then we'll deal with any language review that we need to. Let's see. And last reminder, when it comes time to vote, we'll all need to be on screen. We'll make sure we have a quorum, be on screen to do a roll call vote. With that, I'd like to open up the work session for LD 110, and I will ask Ms. Breton to lead us in the bill analysis. Thank you, Ms. Olson.
I'm not sure if Jody really wants to do that, but she's welcome to take over if she'd like.
Ms. Olson, thank you very much.
You're welcome. Okay, today we're starting with LD 110. I'm happy to put the bill analysis back up, but for reference, LD 110, which is an act to clarify prepayment requirements in home construction contracts. The committee had a work session on this bill on February 10th. The committee voted in the majority to table the bill, and there was a lot of talk around, what the bill was actually hoping to achieve and whether it would do any of those things. And then because it was so early and with the rate of bills that have been referred to committee, we knew at the time that there were other bills of a similar nature, most likely coming to the committee. And we have since had bills related to that topic, such as LD 195, related to general contractors, come out to the committee. We've heard a lot more about the topic. And so we rescheduled the bill to consider bringing it off the table. I'm happy to answer questions about the original bill, about the work session at this point, or to go over anything else from the bill analysis. I did share that to the in my first email of the morning to the committee.
So I will interrupt for a moment and recognize that as I hear when we're at the Senate floor, the chair is in error. I needed to make a motion to bring the bill off the table. So we'll accept a motion to bring this bill LD 110 off the table.
So moved.
Thank you. So moved. Is there a second? And all those in favor with a hand? Having a majority, well, now that the bill is off the table, we have had the bill analysis in the past. Is there any questions for Ms. Olson, or is there actions that any member is ready to make a motion for? Representative Roberts.
Thank you, Mr. Chair. I have a proposed committee amendment to this bill that Ms. Olson has emailed out. I'm wondering if she could go through it, or I can, or both, or.
Okay, so there's a proposed committee amendment. It's not a motion yet, but let's go ahead and walk through it. Ms. Olson, would you care to walk through the proposal, or Ms. Representative Roberts, did you want to explain it first?
I could do that, yes.
Go ahead.
Do you want me to do it while you pull it out? Yeah, that makes the most sense.
Yeah.
So we have had some conversations around licensures, registrations, studies, and there seemed to be a kind of some feedback on the department side of how sunrise reviews were structured, and we had put that in our report back to AFA that we would like for them to have funding for that. But just in relation to any new professional or occupational regulation and any expenses that the department may need to expend or staff that they may not have. I've been working with the department, with AFA. I became aware that the department's kind of in-office budget has not increased in over a decade, which in my view, if that was mine, would hamstring a little bit there, in order to be able to move forth any new, whether it be a study or a sunrise review or anything that the committee was looking to do. So, and AFA members have heard this and have met with the department as well and are in agreement, and basically turned around and said, all we need from the committee is a bill in order to get the department the funding for these new initiatives that may come out. So in collaboration with the department and Ms. Olson, this amendment was created, which is establishing a, what was the title here, Sunrise Review and Legislative Report Fund. And Ms. Olson can probably explain more what it does, but this language was done with the input from the department. It does allocate them funds into a revolving account. It does also put a cap on us though, as a committee, so that we are not putting out, 5 or 6 sunrise reviews. We're only able to use what is allocated in this fund per biennium, so that, there's not a crazy amount of new licensure going on that would burden the department or otherwise. So that's in there as well. Is there anything else? So this is basically, this is a committee bill for AFA to give them a vehicle, to give the department the funds that are needed in order for us to continue our work to be effective as a committee. And as far as the technical language, Ms. Olson can kind of go over that.
Go ahead. Ms. Olson, would you walk us through the technical side to this amendment?
I can. I also see Representative Pebworth has a question. I'm not sure if it was related to the technical portion or not.
Ms. Pebworth, okay. Representative Pebworth, are you okay waiting? Okay, thank you very much.
Okay, so on the technical side of the drafting, so what this does is it establishes a fund within the Department of Professional and Financial Regulation. So it's within Title 10. It's establishing a new section, 8012, but it's within the chapter about the department. And it establishes a Sunrise Review and Legislative Report Fund. This is a non-lapsing fund within the department for the purpose of providing funds for conducting or contracting appropriate services. So either they internally conduct, or in certain cases, which we've heard them say in past work sessions, is that for certain types of studies or sunrise reviews, they would need to rely on outside contracting services, often when it's of a very technical nature. So that's the portion there about contracting appropriate services in order to conduct sunrise reviews pursuant to Title 32, Section 60J, which I think we've heard a lot about. And then any other related studies directed by the legislature. So we also have seen some examples of studies that we ask different, in this case, we asked DPFR to conduct, and that would help. The fund would be used to fund those studies. As Representative Roberts mentioned, it does put a limit on the committee and on the legislature as a whole that they can only conduct sunrise reviews or related studies to the extent funded by the available funds in the fund. Money is appropriated by the legislature, and so it goes into, I believe it would be called an other special revenue fund. And in this case, the balance remaining in the fund at the end of the fiscal year does not lapse, but is carried forward into the next fiscal year. So, theoretically, if during one legislative session, sunrise reviews or reports didn't meet or wouldn't cost the full amount appropriated to it. There would be some left over, so potentially more could be done the next year. But again, that would just be how the money played out. And this is, of course, a budgeting decision that would be made with every budget. It does add an appropriations and allocations section. This is not from OFPR, or it's not from the fiscal office, excuse me. So we would get an official one from the fiscal office, similar to how we did the nursing loan repayment amendment. But the department suggested a $40,000 appropriation each year of the biennium, and that would be ongoing. So the request is that it would be an ongoing appropriation. Happy to answer questions about that, how this is put together. We've seen a couple of bills that create funds, so you should see some similarity in how we structured the language within statute to do that. Happy to answer questions about the proposed amendment.
Are there any questions of, I'm going to ask you to, no, I can see everybody, so I don't need you to ask you to unchair. Chair recognizes Representative Austin.
Thank you, Mr. Chair. Rachel, this, just clarify for me. In the past, any sunrise review, whether it was done internally or contracted out, I would suggest it probably was the commissioner who gave oversight to that and found existing funds within her purview to accomplish when she felt she could. Would that be an accurate history?
I believe that that's an accurate interpretation of how these were done. So they used resources that were already a part of their staffing and or budget in order to do these. I know we've heard Commissioner Head speak about the increase in the number of sunrise reviews and reports that have occurred over the past, I'm not sure the time frame, but years at least, and the technical nature of them requiring more time and resources of the staff and the department as a whole. I believe she's here, though, who she could answer more directly that question.
Representative Austin, would you like me to bring in Commissioner Head?
That would be fine. And I have, after she addresses that, I have one more, and it will probably be best for her too. Thank you.
Okay, great. Ms. Breton, if you could promote Commissioner Head to panelist. And at this point, I think, Ms. Olson, if you could drop the screen share. We can come back to it if somebody needs it. Welcome, Commissioner Head. Representative Austin has a question for you.
Oh dear.
Yes, I did hear the question. So I mean, I'd be happy to answer that. As a matter of fact, I have not used any funding from existing programs in 04 or the rest of the department. The staffing was mine alone. I worked after hours to complete what was asked of me as commissioner, and I did have some assistance last session from Joan Cohen, but it was a monumental workload, and I just don't think I can do that again. So the answer is I did not use any funding from 04. So that's the answer to Representative Austin's question.
I thank you. Historically, I knew that you didn't seek additional funds outside. I just didn't know how you were able to accomplish that. So I appreciate that information. And question 2 is, you've given us estimates, I believe, just this year, but again, I'm looking for a little bit of a historical landmark, if you will, on how much some of the studies, what's the variation? I know it would depend on complexity, et cetera, but what would be the ranges of the work that we are proposing to have funds for? Can you give us some estimates? At one time I thought I heard you say something about 20,000, One time I thought I heard it was a different area and I thought you said 10,000.
Representative
So-
Austin?
Yes. What?
Representative Austin?
Yes. Can't hear me?
I think there's just a glitch. I think you're. I think
Am I
there's just a
coming
computer
back or-
glitch. We can hear you.
Okay, so did Commissioner hear me?
Yes, I did. I did.
Okay, I'm sorry. Everything's
okay.
everything's blinking on this end. I've got a beautiful, colorful square going blink, 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 blink around me. So go ahead, please.
Okay. Yeah, I do understand that the dollar amount has shifted from our first, when we first started discussing this a couple of months ago, and in discussions with both my financial advisor here in the department, with Joan and some others who I rely on in the Bureau of Insurance, we decided that if this was going to come to fruition, we should ask for what we know is going to be enough to serve this committee. And we landed on 40,000. If it's not used, it will be carried over, but the limit is 40 in each biennium. So we thought that was appropriate, and that's what happened. So my earlier discussions with you, I provided estimates. There was nothing scientific about it. I have not used consultants in the past for this, and I frankly don't have a lot of experience with an RFP for that kind of consulting service.
Thank you very much, Commissioner. If I could shut something off, I don't know.
Was I the only one that froze up there for a bit? Okay, great.
I don't know.
You and Roberts.
Okay, well, oh, great. Only the chairs froze up. So,
I had to leave and come back in.
yeah, chair recognizes Representative Pedworth.
Thank you. I am ready to make a motion not to pass as amended when appropriate.
Are there other questions? Seeing no other questions, Representative Austin.
Thank you, Mr. Chair. I'm wondering if we could just take a really quick caucus.
Certainly.
Five minutes.
Representative Roberts, you had a question?
Yes. Can we just pull Representative McCray in for a moment?
Representative McCray?
This originally was her bill, so I just want the committee to know.
She is, I'd be happy to do that before we caucus.
Yes.
And I don't see Representative McCray in, oh, there, she's already in the panelist list. Welcome, Representative McCray. Thank you, Representative Roberts, for noticing that. Are you with us, Representative McCray? There you are. We can see you now. And you're on mute. You're on mute. Here, I will see if I can unmute you, or at least ask to unmute you. Maybe that will give you a prompt. Remove spotlight change. I think I just muted you accidentally. There you go. Oh, it was there for a moment. Try again. One more time. There you go. It says you're unmuted, but we can't hear you. I think we'll go to caucus and maybe you're for this proposal. Okay, I'm taking the thumbs up as in favor of this proposal. That's a new adventure in committee leadership. and committee experiences. So at this point, we will caucus. Is 5 minutes enough, Representative Austin, Senator Searway? Great. If folks can turn on the cameras, just to let me know they're back. Chair recognizes Representative Roberts.
Thank you, Mr. Chair. I believe Representative Pebworth was about to make a motion.
I'm sorry, I thought that was you. Chair recognizes Representative Pebworth to make a motion.
Thank you, Mr. Chair. I would make a motion to pass as amended.
And the amendment being the Representative Roberts proposed amendment or introduced amendment?
Which was just presented to us, yes.
Yep. Great. Is there a second? So it's been moved and seconded. Is there any further discussion? Are we ready for a vote? Representative Collmore.
Thank you, Mr. Chair. While I want to ensure that it's understood that I certainly appreciate that the commissioner needs funding to be able to do the increasing number of reviews that come her way. I think that what I'd like to see is have the fund start a little lower and see where it goes from there, instead of committing $40,000 every year, especially on a rolling fund, when we're so strapped for money as it is as a state, and our taxpayers already have quite the burden. So I would not be able to support it in its current state, but would support it if the funding amount went down to $10,000. Thank you.
We have a motion before the committee, and I will check in with Representative Pebworth. Was that I can hear that as a friendly amendment, and you're welcome to accept that if you wish, or that could be a part of a minority report after the fact, after the vote.
Thank you, Mr. Chair, and I appreciate that suggestion. I'm not willing to go much lower, listening to Commissioner Head and her needs.
Okay, so we'll stay on this, and that will be ready for a minority report. Are there any other comments? Seeing none, I will ask Ms. Breton to call the roll.
So I have an ought to pass as amended by Representative Pebworth, seconded by Representative Geiger. Representative Geiger.
Yes.
Representative Geiger, yes. Representative Andrews is absent. Representative Pebworth.
Yes.
Representative Pebworth, yes. Representative Collmore.
No.
Representative Collmore, no. Senator Lucchini is absent. Senator Seaway. I think you're on mute, Senator.
No.
Senator Seaway, no. Representative Ducharme, I think is absent now. Representative Austin.
No.
Representative Austin, no. Representative Hassenfuss.
Yes.
Representative Hassenfuss, yes. Representative Bailey.
Yes.
Representative Bailey, yes. Representative Bernard is absent. Representative Roberts.
Yes.
Representative Roberts, yes. Senator Curry.
Yes.
Senator Curry, yes. That's 6 in the affirmative, 3 in the negative, and 4 absent.
With 6 in the affirmative, 3 in the negative, and 4 absent?
Yes.
4 absent. Thank you. Yep, that works out. Then the majority of those present report will be ought to pass as amended. There is, for those present, the minority report that you wish. Representative Collmore, do you want to lead off?
Yes, thank you very much, Mr. Chair. I would like to say ought to pass as amended, but striking the $40,000 and putting in $10,000 instead.
And Representative Austin, is that your minority report as well?
Yes, thank you for asking.
And Senator Searway?
The same, yep.
Okay, so we have a majority report ought to pass as amended A, Minority report ought to pass as Amendment B, and then 4 absent. Ms. Olson, is that everything you need?
It is, thank you.
Thank you. So with that, we will close the work session on LD 110. And we will move on to, I have no idea what the next one is. I'm sorry, 210. Is that 210? Is that what's next? Thank you. So LD 210. There's just, I'm short one screen. I need one additional screen that has the committee order. So bill order. So opening up the work session for LD 210, Ms. Olson, can you update us and walk us through the bill analysis?
Okay. I think I'm sharing my screen. I think I'm unmuted. So LD 210, an act to require crane operators to be licensed. When the committee heard this bill, it was originally in a concept draft. The bill proposes to require licensure of crane operators by the Department of Professional and Financial Regulation. I will mention that when we had the public hearing, the sponsor did submit an amendment to the concept draft, so that was available at the time of the public hearing. And as background, a Sunrise review regarding licensure of crane operators was completed by the Commissioner of Professional and Financial Regulation in 2020, pursuant to Resolve 2019, Chapter 75. I believe it was January of 2020. And this is another example of legislation that wasn't able to move forward as a result of the changes in timeline from the pandemic. The amendment that Representative Cuddy submitted is included at the end of the bill analysis. So I did have some information requests that I'd like to go over with the committee from the public hearing. The first one, the committee had asked how many accidents and or fatalities have occurred as a result of crane operation in recent years. So I pulled some data related to this topic. According to the OSHA database, there have been 60 reported serious accidents or fatalities as a result of crane operation within New England between 2002 and present. Of those 60 accidents, 31 were reported fatalities. There were 4 reported incidents within the state of Maine, 3 of which were fatalities. And then there was some talk about some states that already license crane operators. And so of the New England states represented in that data, Massachusetts, Connecticut, and Rhode Island have some type of licensing provision in place. And I've included details relevant to those states and to that data. So you can see the OSHA crane injury list for which I'm referring to by checking this link. It has the 4 cases in Maine, and it tells you what happened in each case. And then there's a report that I also included from the U.S. Bureau of Labor Statistics on fatal occupational injuries involving cranes that was released in May of 2019. As background to that report, injuries and fatalities related to cranes has been a serious topic for OSHA for, I'm going to say, many decades at this point, as back into the 90s. And OSHA has been taking steps to address the seriousness of workplace injuries involving cranes. And as a result of that, there's been federal rules promulgated related to crane and crane operators, which I'll talk about momentarily. Additionally, there were questions around, about states around Maine that have licensing programs. From the Sunrise Review, it was noted that according to the NCCCO, which is a national certification organization for crane operators, there are 16 states that license crane operators, and you can see them here: California, Connecticut, Hawaii, Maryland, Massachusetts, Minnesota, Montana, Nevada, New Jersey, New Mexico, New York, Pennsylvania, Rhode Island, Utah, Washington, and West Virginia. 34 states do not license crane operators. In November of 2018, an OSHA rule regarding crane operator certification became effective. This is a rule that was promulgated, I believe, almost a decade prior to it going into effect. The original rule had a 4-year implementation period, which was subsequently extended, and the rules needed clarification, but the final rule became effective in November of 2018, and that requires all crane operators in the United States under OSHA regulations to be certified by type of crane and to recertify every 5 years. The certification comes from a recognized certification organization. NCCCO is by far the most prominent of those from what I could tell in my research. It also requires that employers must evaluate their certified operators and that the employer is responsible for the training and retraining of their operators. And I've included those rules within the supplemental materials, and I can answer some questions, although I'll admit this is a highly technical topic. I've done my best to become familiar with the rules and regulations. I get lost in all of the type of equipment, but I will do my best to answer. I know we have experts who can speak more to that. I did provide a side-by-side of the 3 New England states who license crane operators. That's in the electronic LD file. You can also hit the hyperlink, and I can go over some of that as well. You'll see, though, in the side-by-side that some statutes are very detailed and others leave a lot up to the rulemaking, but I did talk about who's responsible for the rulemaking and the advisory portions of crane license or licensed crane operators.
I'm going to ask you to pause for a second. Senator Searway, you have a question?
Yes, thank you, Mr. Chair. Ms. Olson, what would you say about if we mirrored the federal standards and as certification rather than licensing? Because I think licensing, it takes, from what the commissioner had said, that it would take like a 27-member panel for 5 licenses. So I think if it could mirror federal standards and have a certification, that should pretty much handle it, I would think.
I'll just answer the technical portion. I can't tell you, obviously, an opinion. All crane operators within the state are already required to be certified under this OSHA rule. Certification is voluntary and is not regulated by the state. If we were to move forward with licensing, if the committee is to move forward with licensing, many of the states that I've listed that have licensing laws, I would say the majority, if not all of them, are based on the OSHA standards, which set a minimum requirement. And then, so a lot of the states in their requirements for crane operator license require one component is that they are certified by one of these national organizations. So that would be that sort of information to that. But certification is voluntary. If you were to require certification, that is headed into the realm of licensure if you required it.
Okay.
I did submit information that goes over that through email, also talks about registration as well.
And just a follow-up.
Go ahead, Senator Searway.
So can these companies have policy of just meeting that they have to meet certification in order to use them? Even though it's voluntary?
Right, yes. So OSHA rule requires certification. So my
Okay.
understanding is that in order for these employers to be compliant with OSHA, they have the crane operators have to be certified and then recertified every 5 years. And they're certified, they do have a slight, when you get certified, you're certified on the type of crane. And there are sort of 3 big categories and then some specialty certifications, but you'd be certified by the type of crane. And you are in fact required to be certified by your, to be certified to be working as a crane operator.
So it's already being done then.
Chair recognizes Representative Roberts.
Yeah.
Thank you, Mr. Chair. Just maybe this will help clarify. Ms. Olson, once you've gone through this document, can you just quickly go through what you emailed out to us as far as what the state is able to do. I think there's confusion around certification that the state doesn't certify. It's not something that we do. So if you could go over that document right when you're done with this, I think that would be helpful for this and following bills that we're going to deal with around licensure and everything like that.
Yes, sure. Let me just wrap up the information that the committee requested originally through the bill analysis, and then I'm happy to shift over. I'll have to stop screen sharing in order to pull the document up myself, but just to kind of follow up what I was saying about the certification. So federal certification through OSHA, the OSHA rule requiring certification, that is, as I said, the floor, if you will, the minimum. And states that do license can require more. Those certainly vary state by state, but examples of things that they could require that go above and beyond include medical evaluations, like heavy equipment, other types of like truck drivers might have to get. Make sure your vision and mental competency might include substance screening, etc. So there are definitely other levels of requirements that go above and beyond the federal rule. So the federal rule is the floor. In terms of additional information from the testimony, there are two things to consider, one of which I've already spoken about. That comes with the concerns over the definition of crane as provided in Representative Cuddy's amendment. And in my study of crane licensing laws across the board, what the definition of crane is varies widely state by state, and more importantly, what is excluded from the definition of crane varies widely state by state. And in the side-by-side, you can see pretty extensive lists of what's included and what's not, and that is different from the various states that require licensing. And then, as I mentioned, NCCCO did submit testimony, neither for nor against, just to speak in general, but did submit the considerations for the committee is that in considering proposed licensure systems, that they should meet the established minimum set by OSHA, and that the primary component for licensure should in fact be the holding of a crane operator certification through or from a nationally accredited certification body. We don't have a fiscal impact as the bill is technically still a concept draft for the official offices, so we don't have that information at this time. And as I said, the sponsor's amendment is below. I'm going to stop sharing and pull up the other information that Representative Roberts requested, but I think I can multitask. If there are questions I could answer for the committee while I'm doing that.
Chair recognizes Representative Pebworth.
Thank you, Mr. Chair. Thank you so much for the analysis. I wasn't able to make some of the links work, and one of them was the side-by-side comparison. I wonder if it's possible to email that or...
Yes, it should be uploaded into the electronic LD file as a separate document as well.
Do you know what it's named there?
SBS.
Thank you very much.
Sorry, yeah, the acronym for side-by-side. My apologies. The system of uploading things to the electronic LD file, you have to do each one at a time. I'm not sure if you have had the chance to submit testimony that way. Can be. Okay, I'm ready to share the overview of the different levels for professional and occupational regulation.
Representative Collmore, you had a question before we moved on?
Yes, thank you, Mr. Chair. Ms. Olson, when you were looking through this, I was trying to look back in my notes from this back February 23rd, by the way, is when we heard this. So I'm trying to remember when we discussed this. I thought I remembered hearing that none of the states that have licensure laws have them following the OSHA regulations. All of the licensure laws are before the updated OSHA regulations. Does my memory serve me correct?
I believe that we did hear that mentioned. I would need to consult my notes for exactly who said that. And the answer to that is rather complicated, and I wasn't able to discover the complete accuracy of that point. Certainly one of the laws that I looked at had a history going back to the 1940s. But that's just its written history. So no real idea of what it said in the 1940s without much more extensive research into the other states' historical statutes. I couldn't pull that necessarily. But as I mentioned about the OSHA standard, I believe that originally was issued, I want to say I have to, I'm sorry, I can't remember off the top of my head. It was the early to mid 2000s. And it's been about a decade since the original rule was promulgated. And it had, as I said, a 4-year sort of delayed implementation that was then extended and then further extended for clarification of the rules. So it's only been a final rule in effect beginning in 2018. So it's a harder answer depending on how you interpret this federal rule. So, I mean, if you use the 2018 date, then yes, they were all created before, I believe.
Chair recognizes Representative Austin.
Thank you, Mr. Chair. Rachel, I'm wondering if that might have been information that Mr. Cody out of Auburn might have given to us. I was trying to remember some of his testimony. He was pretty articulate in the oversight and the thoroughness of his company. So it might be there. I don't know if that will help you at all, but thank you.
Representative Pebworth. Representative Pebworth, did you have a question?
I neglected to lower my hand. I apologize.
Okay. I think we've handled all the questions. Ms. Olson, would you mind walking us through the background information Representative Roberts requested?
Yes. So the committee has been considering a number of bills that will require some type of regulation of an occupation or profession. So I've pulled information that over the work of many different bills and testimony DPFR has provided to the committee in regards to the options available for professional and occupational regulation. And they're included here on the document you can see on your screen. They go in order from least involved to most involved. So obviously the least involved would be no regulation at all. It's unregulated at the state level, and therefore, of course, there are no staff costs involved in doing that. The next level is considered certification. So, and to be clear, certification is a voluntary process by which a third-party entity, such as a private, non-governmental trade or professional association, administers a training or examination to interested individuals. The state in that case has no enforcement or regulatory role in certification, and it does not result in any state authorization or permission to practice an occupation or profession. However, this is what I think where we see some confusion. A state licensing entity may require certification for some professions and occupations. There is no staff cost involved in certification. Of course, there would be if the certification was a part of licensing. So for an example, the committee considered the bill related to sign language interpreters earlier this session. And within the sign language interpreter bill, the committee considered they were required to be certified by the national organization called RID. So that would be an example of a license issued by the state that requires certification from a third-party, non-governmental professional organization. So that would be an example of that. So, but that is a licensing provision that just requires the certification as one of its components. Going again from least to most involved, you have registration. So registration is a mandated process by which a member of a profession or occupation registers with the state, generally with a fee required. However, there is no set of standards or qualifications required for registration. That would be up to the policy committee to decide. Registration provides a state with the ability to keep track of individuals who are practicing a certain occupation or profession. There is some staff cost involved, but to a lesser extent than licensure. And of course, the requirements for registration would, and the number of people who register would dictate the costs. Registration is the least burdensome form of state regulation of professions and occupations. And then finally, we have licensure. This is non-voluntary. It's done through an agency of government, and they are regulating that profession. Licensing is always based on the action of a legislative body. Once a licensing law has been passed, it becomes illegal for anyone to engage in that occupation unless he or she has a license. Licensure grants a member of a profession or occupation with the authority to work, contingent upon that member meeting a set of established criteria. This usually involves educational, experiential, training, and competency-based standards, and paying a required fee. Continuing education, regular testing, or re-education or training may be required. Licensure also involves a process by which the states investigate complaints registered against a licensed individual and imposes discipline as necessary. And licensure, of course, can vary in its degree of complexity. The state may employ a board to administer the licensing program, or may choose to manage the license program directly. And of course, we have both types in Maine law. Most regulated entities in Maine are licensed as opposed to a registration. Licensing is the most burdensome and costliest form of state regulation of professions and occupations. And as we have heard in the past from DPFR, the licensure should be considered for the protection of the health and safety of the public. That is in the statute's mission for DPFR and the licensing around the Sunrise Review process in creating new licensures.
Ms. Olson, can you give us an example of a registered occupation where registration is required? But there's no standards.
I can't off the top of my head. I don't know. I'm not aware of any. That's not to say they don't exist. I just don't know if there are any. Okay. Again, there are probably people who can answer that
in the waiting room. Yeah.
In the waiting room, but I'm unaware of them within the state.
As you described that, I thought instantly of the Registered Maine Guide, but the Registered Maine Guide is really a license. In that it has standards and has testing and qualifications. So.
Yes, so that's the other point of confusion, is that at times the terminology used to describe the occupation or profession doesn't actually align with what the system that's actually being used.
Gotcha. Chair recognizes Senator Searway.
Thank you, Mr. Chair. Yeah, I was thinking about that, and I know when we get certified for OUIs, and we have to be able to use the OUI testing machine and all that. We get a number assigned to us and a card that we are certified to use that machine, and also to be able to do the test for people operating under the influence. So it can be done, and it probably is being done. And so I don't see where we need the licensing. I can see the licensing for maybe the company, or maybe in that respect, but when it comes to just the job itself, I think that's where we should be looking at what's being done already. I think policy is what kind of governs that.
Senator Searway, I want to make sure we give time for the bill sponsor for clarifying questions, and we'll get right into debate in just a moment here. So I will ask Ms. Breton to bring in Representative Scott Cuddy. Welcome, Representative Cuddy.
Thank you very much.
Thank you. I wanted to we have a practice of giving the bill sponsor an opportunity to speak. You've heard the bill analysis. what would you, what would you like to share? Can we give you a minute or two to make your case there?
Sure. I think your analyst has really done an excellent job with the bill. I did look through after the hearing definitions of crane operator, and found that the definition as written, it specifies construction. I think a reasonable person could interpret that definition to understand with the legislative intent what we actually want to do, which is only to affect construction cranes and the operators of construction cranes. The analysis also pointed out fatalities in the state of Maine and elsewhere, and that indeed there have been serious issues. And licensure is the only way that the state of Maine has to know that the right people are operating these cranes. So the analysis of the bill confirmed, I think, what we knew from boots on the ground time, but the analysis confirmed that. So all in all, I think I knew I was on the right track before, but I feel better about that now, having heard the analysis.
Representative Cuddy, I'll have a follow-up question. So currently OSHA requires the certification. The standard is the same in the current statute. Talk to me about how it would be different with regard to enforcement. So what, if the feds are already doing it, the question is, why does the state do it? What can you address that? Where the benefit lies from your perspective?
Sure. Thank you for the question, Senator. The sort of operative part of your question is if the feds are already doing it. And right now, the requirement for enforcement of whether or not somebody meets the standard, the federal OSHA standard, is only being overseen by OSHA. And as was discussed previously, OSHA has limited resources, and it is not, from the people I've talked to who are involved in the industry, it's not sufficient. And this would be a way that the state of Maine could ensure within its borders that the standard is being met appropriately. So it would assist also in enforcement.
So is this the primary benefit from your perspective, the enforcement aspect of it?
I don't know that I would say it's primary, but it is definitely a big benefit. You have the benefit of certainly of having the ability, the state having the ability to enforce as well. But you also have the knowledge that each individual who's climbing into a crane is a licensed individual, or you can check that more easily.
Great. Thank you very much.
Certainly.
Chair recognizes Representative Collmore.
Thank you, Mr. Chair. Thank you, Representative Cuddy, for joining us today. I remember, again, this was back in February, so please correct me if I'm remembering this wrong, but that we had received testimony from, I want to say it was Mr. Marks, who had said something along the line of that there are 4 OSHA inspectors in the state of Maine that regularly go to the job sites and check to make sure that the crane operators are certified. And I'm curious as to how this would improve the current processes if we're already having that done. And I know you're saying that it's not the primary benefit, but most of the testimony we heard was based on trying to encourage the state to be able to take more ownership over the program instead of the federal government. And that's not a safety concern, which should be the reason behind licensure, as we heard from Commissioner Head. So I'm curious, first of all, if I misremember that number, and how a licensure program will actually improve the current processes, given OSHA's extensive overview of crane operation.
Thank you very much for the question, Representative Collmore, and it's nice to see you in your committee as opposed to seeing you earlier today in my committee. Although, strangely, neither of us have probably left the room that we were in when all that happened. So I would push back a little bit against the idea that safety is not part of this, because I think safety is part of this. It's knowing that the individual, as I said, who's climbing into the crane is a licensed individual. The only way that we can know that is to have the ability to enforce and check on that. So the safety element follows, or I should say the enforcement element sort of follows along with the safety element of this. And I do remember Mr. Marks' testimony. I do not remember the numbers that he gave, but I know that with the case of, by analogy, with electrical inspectors, there are 6, and it is nearly impossible to get electrical inspectors to come around quickly. You know, everything's scheduled pretty far out. They don't have time to do drop-in inspections for the most part because they are just right out straight. So the idea that that OSHA is doing extensive work on this, I don't think that that is actually the case, which is why this was brought to my attention by folks who work in the industry to begin trying to get a licensure program in place.
Thank you. And Ms. Olson, I wanted to follow up. Was that, I seem to remember that question. Of number of OSHA officers that were in Maine or in New England that dealt with cranes, and what was the nature of that? Are those scheduled events? Are those drop-in? How does that work? Did you find any information on that? Did we ask you for information on that? I'm trying to remember.
I didn't have a specific request for that. I did. You'll have to forgive me if it was recently that we had that, or if it was in fact had to rewatch this video of the public hearing. So I could just be thinking about the video. There are 2 OSHA offices here in the state of Maine, I think in Augusta and Presque Isle, Caribou. Representative Bernard is not here to correct me. So I believe that there are 2, and then of course I believe they have their New England regional office out of Boston. So short of that information, I could not identify the exact number of inspectors and if they specialize in what they inspect. Of course, OSHA covers significantly more than cranes. So no, I don't have any detailed information on that process.
Thank you. Representative Cuddy, did you have a different response, as your hand just left up?
No, my hand is up actually because I'm being called back to EUT to vote in a work session. I will still be available because they're on my phone, but I just won't be able to listen or address a question for the next minute or 2.
Thank you very much. 'Tis the season. So
yes.
So Representative Hassenfuss.
Thank you, Mr. Chair. This is kind of slightly addressing the questions that have come up. A while back, I actually had a phone call with Dave Meegan, who is the area director for the OSHA in Maine, because I had this, the same question: is the OSHA standard enough, or do we need more? And one quote that stuck out is he said, we never have enough staff. And he said that about 80 to 90% of their investigations are after an accident's already happened, and that they very rarely do any preemptive inspections of anything. And I can't remember the exact number of inspectors, but I think it was something like 4 for the entire geographic scope of Maine. And usually they're out on a call because they're inspecting an accident that had happened, for anything, and not just cranes, but any occupational hazard. So my interpretation from that phone call was that OSHA doesn't really have the capacity to preemptively inspect cranes and make sure that they're safe and up to standard. Which of course that's based on the conversation I had with him, but he was more than happy to talk with anybody if they would like to reach out.
And who was this again?
This was Dave, and my notes are terrible here, but it was Dave McGann, McGann, or something along those lines. It's right online if you look up Maine OSHA. He's the area director out of Augusta.
Thank you. And I see that Commissioner Head is in the attendee list. I will invite Commissioner Head in. And we'd also ask Mr. Marks to come in. Welcome back, Commissioner Head.
Thank you very much.
And I just wanted to ask you any additional thoughts on this that you wanted to address with regard to the proposal?
Yeah, just a couple of things. When I was doing the work of the Sunrise Review, it appeared to me, speaking with any stakeholder that was involved in this area, that there was a three-way prong of responsibility for safety around cranes and other construction equipment. And obviously the first, as you've heard from Rachel, is the OSHA statute and rules that have been in place for several years. I did talk to Mr. McGann myself during my research, and that was not, I don't want to, we were having a conversation. I did not get the same impression that Representative Hasenfuss had, and I'm not sure why, but there are three things. OSHA, the employer of people who operate cranes, and NCCCO certification. Those three prongs created for states a safe working environment. Theoretically, there will always be accidents. In my research on the same fatality issues, there were many years where, as I looked at the last 20 years, there had been 9 incidents, not all of them fatal. So I think we may be looking at different statistics. So I think the committee has the information that has been collected, and the decision what to do is yours. And I understand that. The one question I have is about enforcement. And I don't know who this question should be directed to, but I would like to know what enforcement is envisioned by the amendment that Representative Cuddy has presented. What does that look like? Just a question.
Thank you. And I appreciate it. And I actually asked Representative Cuddy, are you in a position where you're able to respond to that?
I am now, thank you. Yeah, luckily I was able to jump in and vote, and then the chair excused me and I was able to jump back out. So it's better than having to run across the hallway in the Cross building. Yeah, so as I envision it from the amendment, my hope would be that we would be able to have inspectors doing this kind of work. And we also then have the opportunity, because it would be state licensure, to bring in the AG's office as well.
Thank you. At this point, I'd like to, let's see. Any other questions? Representative Roberts, were you looking to did you have anyone else that you wanted to hear from?
Can we bring in Mr. McAvoy, please?
Sure.
Thank you.
And I realize while that's going on, I requested Mr. Marks to come in. Mr. Marks, I understand you believe you had information regarding number and access of OSHA staff in the state. Is that correct?
Yeah, I think Representative Cuddy was pretty close on those numbers. So 4 folks are inspectors here that have crane experience or education related to inspecting cranes. But there's not, I think there's a total of 9 folks in the office who can inspect. And one of the rules is that the crane in the air, they're supposed to stop and inspect this. It's one of their serious focuses. So I'd say that to answer your question, that's the exact numbers 4.
Thank you. And Mr. Marks, remind me what organization you're with?
Yeah, I'm with Associated General Contractors in Maine. We actually administer the NCCCO testing here in Maine for both members and non-members. I would just tell you that, one of the questions that you had was about state licensing, and I think I actually brought up what states had licensing prior to the OSHA rule. I know that was mentioned, and I can tell you that like the state of West Virginia just rescinded their licensing and just changed the rule over to recognizing the NCCO certification. So I think it was us who did that research before, if that's helpful.
Thank you very much. I appreciate it. And I will ask Ms. Breton if I think we've handled all the questions except for Mr. McAvoy. So I'm going to ask us to promote folks back to the attendee list, except for Mr. McAvoy and the committee members. So, and Mr. McAvoy, I believe Representative Roberts had a question for you.
Yeah, thank you, Mr. Chair. Mr. McAvoy, there have been quite a few questions that I believe you can provide some input on that haven't been answered yet, or clarify regarding licensure, its benefits, its safety benefits. If you could just cite your kind of background and go from there, that would be helpful for the committee. You're on mute. There you go.
Yeah, I am the safety officer for Local 4, the operating engineers. I'm also the lead instructor at the training center, and I do all of I run our test site. I'm a test site coordinator for that, and I'm on several NCCO boards and things of that matter. So I'm an industry expert according to them. Did you
just dive right in? What I'm sure you have a couple of answers.
I think there's a lot of confusion as far as OSHA's enforcement of this regulation. A lot of disagreement, quite frankly. I'm in the middle of 2 crane investigations right now of accidents, and I was told that the crane expert is a gentleman that went to the operating engineers training center in Chicago, Local 150. They go for a week, and they put them through a small little course, and then they're the crane experts, and that's the level of their experience. So it's not a lot of thing. To give you an idea, our NCCO certification class is about, I know it's 6 months long, but it's about 15 classes or so, 2 a week. So there's a lot of knowledge to try to squeeze into 1 week. We're still going through an accident right now. The accident was March 23rd. It took place down by the Bourne Bridge in Cape Cod. It was a 300-ton crane with 450 foot of boom on it. It went over. It was operating in 45-mile-an-hour winds, which is forbidden via OSHA and the manufacturer. It landed about 25 feet from the highway, the tip of the boom, on a Friday afternoon, which you can imagine the traffic there. I arrived after the operator called. There's no police response. There was nothing. OSHA showed up the next day around 3:30, and very nice guy. He explained, he apologized for being tired. He had just finished staining his deck, because it's not a work day. It's not some readiness force that comes out. He had no crane experience. He took some pictures, took some notes. I didn't hear back from him until last week. He wants to schedule an interview with the operator, who does not have a CCO. Never has. No one's asked for that yet. No one's asked for the operator evaluation from OSHA. Maybe they plan on doing that next week when they meet. I was informed by him that there was this is the second accident that this company has had, well, I won't say, but this company has had installing these windmills. And right now we've attributed that crane company as the bad actor, not following policies and not abiding by the wind conditions. The only recourse we have is through the State Department of Public Safety, because they are using people without hoisting licenses. So we've turned our attention on them, and we'll send the DPS down there to check their licenses as some sort of enforcement, to stop an accident before it happens. So that's one great example how the licensure is able to assist us in getting rid of these bad actors in the hoisting world.
So that would be addressing safety and enforcement at the same time.
Yes, yeah. I mean, ultimately, safety. That's the issue here. Is there's a lot of money to be made if you can cut some corners and not have accidents. That culture is changing because of how much these accidents cost, and obviously the loss of lives. But there are still many outfits out there that will try to save a buck by saving a little time, as well as operators and crew members out there on a Friday afternoon is when most of our accidents happened. They want to go home just like everybody else. They cut a couple corners, and this is the result.
Thank you.
Chair recognizes Senator Searway.
Thank you, Mr. Chair. Is Mr. Cuddy still on?
We can bring him back in. Yep. It was getting crowded, so I sent everyone off.
Yeah.
So yes, Ms. Breton, can you bring Representative Cuddy back? Welcome back, Representative Cuddy.
So thank you, Mr. Chair. Mr. Representative Cuddy, isn't licensure is a consumer protection requirement, and it's not for safety. It's more for a consumer protection requirement. And so, do you know if any other licenses that have been created for safety only exist?
I think I would push back against your principal statement that it doesn't have to do with safety. Much of the as Commissioner Head actually said during her testimony, that much of the rationale for licensing in the state of Maine, particularly the trades, is around safety. And you can make an argument of public safety versus safety on a job site, perhaps, but I think safety actually is an important part of it. As an electrician, as a licensed journeyman electrician, one of the reasons that I need to be licensed is so that people fully understand that I know the code. And if I come into your house, I'm not going to wire it in such a way that, I put small wire on a big breaker and you end up putting too much current through it and it starts a fire. So I think safety actually is an important reason.
Isn't that more for consumer protection though? The licensing part?
I think, it is consumer protection insofar as you're keeping them safe. It is possible, we license accountants, so you are offering consumer protection there because you could say the safety of their money, I suppose, if you wanted to put in a safety context, their financial safety and well-being, but that would be a consumer protection. But you also there's certainly a public safety component to the Sunrise review.
Thank you.
Thank you. Chair recognizes Representative Collmore.
Thank you, Mr. Chair. This question is for Mr. McAvoy. Mr. McAvoy, thanks for joining us. It's good to see you again. And I'm curious, with the incident that you were discussing with us, if that, I assume, first of all, that incident is in Massachusetts and not in Maine?
Yes, it is.
Okay, great. So with that, you guys have in the state of Maine licensure processes, but you're saying that even with that, your only recourse was to go to the public works or public safety side. How would that change, be any different than here in Maine, where OSHA already has a requirement for certification? I'm just trying to see if it's worth having a redundant policy in place.
So in Massachusetts, we have a standalone crane license along with that. So that was our means of enforcement, was using that. You know, we can enforce that they have to have that crane license, which is something Maine could do. At least if you had, in this particular case, we have a bad actor from out of state who's coming up, and they're sneaking onto, well, I shouldn't say sneaking, they're doing this windmill work without licensed operators. And they've had 2 incidents in 6 months. And the only recourse we can get is that the Mass Department of Public Safety, who enforces our license, very similar to this license, is able to shut them down that way. So I think it would be, you know, it would be the same type of thing if we had someone that was going into Maine and we had some Maine licensure, they could certainly stop that guy from operating.
Follow up, Mr. Chair?
Please.
Thank you. So if you did not have the licensure program and it was only the now, 3-year-old program for the OSHA, would you not be able to, because that federal law supersedes safety-wise, that you wouldn't be able to shut down a company who has made poor decisions in letting unlicensed, in your case, unlicensed, but it would be uncertified people. You would have no recourse without a licensure program. Is that correct? Or you would because of the new federal guidelines?
I would say I would not, because we couldn't go after the individual operator. So if the company gets caught and they get a $500, $3,000 fine, this particular crane is probably about a $5 to $10 million crane. They would pay that out of their pocket money. The operator himself, if he runs unlicensed, he is subject to a fine of $500 to $3,000 and up to 3 months in jail. So there's that extra added onus on that individual operator to be safe and to follow the rules. The OSHA standard is great, and we do love it because it puts it on the employer. The issue we have is these unscrupulous employers do not care about simple fines and that stuff, whereas our guys that are held to this licensure standard, they lose their license, they lose their livelihood. So if it's Friday afternoon and the foreman says, hey, boom it down, and you're not supposed to, you say no, and hey, they fire you, you know, the real concern is losing that license. So it's just an extra protection for that operator to say, hey, I got my license to worry about, not just you guys getting fined. You're telling me you don't care if you get fined, just do it. It's me losing my livelihood. So we feel it's a great protection for the operators as well.
And one last question, if I could.
One more.
Thank you. I don't know if this would be addressed to Mr. McAvoy or Representative Cuddy, but it's my understanding the way this bill is currently written, it doesn't actually go, as Massachusetts appears to, directly to the operator. It appears to go to the company. So if that's the case under our bill, that would still be the same under the certification process. Am I understanding that correctly? Or have I misunderstood the bill?
This sounds like a question for Representative Cuddy.
Okay, thank you.
Thank you for the question, Representative Collmore. The bill requires that the individual be licensed. So this would be for the individual. This bill actually does not demand that the company do anything. The license is held by the individual.
And thank you very much. I don't see any other questions. Are we ready for a vote? Chair recognizes Representative Roberts.
Thank you, Mr. Chair. I'd like to make a motion ought to pass as amended with Representative Cuddy's amendment on LD, what are we, 210.
210.
Thank you.
Is there a second? Yep, there's a second. Excellent. Senator Searway, I saw your hand. Did you want to make a comment?
Yes, I mean, I can't vote for this. I've been listening. Licensure is not going to shut a company down. I don't believe licensing is going to make the difference of a safety issue. These people are trained, they're certified, they're following federal guidelines, following OSHA guidelines. This licensing is just a way to prohibit other people to even, I think, other people to be in the business. And I just think that this is going to hurt more than it's going to help. And to have a 27 panel member for licensing when you only get like 4 or 5 operators in the state, I think it's quite a bit of adding a cost that we don't need. So I'm ought not to pass on this.
Are there other comments or questions? Are we ready for a vote? Ms. Breton, we'll call the roll.
So I have an ought to pass as amended motion made by Representative Roberts, seconded by Representative Pebworth. Representative Geiger.
Yes.
Representative Geiger, yes. Representative Andrews, absent. Representative Pebworth.
Yes.
Representative Pebworth, yes. Representative Collmore.
No.
Representative Collmore, no. Senator Lucchini is absent. Senator Seaway.
No.
Senator Seaway, no. Representative Ducharme.
No.
Representative Ducharme, no. Representative Austin.
No.
Representative Austin, no. Representative Hassenfuss.
Yes.
Representative Hassenfuss, yes. Representative Bailey.
Yes.
Representative Bailey, yes. Representative Bernard is absent. Representative Roberts.
Yes.
Representative Roberts, yes. Senator Curry.
Yes.
Senator Curry, yes. 6 yes, 4 no, 3 absent.
With 6 voting in the affirmative, 4 in the negative, and 3 absent, we will get ready to wrap up the work session on LD 210. I want to check in with Senator Searway. You mentioned, is your report ought not to pass? Yes.
Yes.
Yes. And Representative Ducharme? Yes.
Yes.
Representative Collmore? Ought not to pass. And Representative Austin? Ought not to pass. I'm seeing head shake, so I will agree to, does that work for Ms. Olson?
Yes. So my understanding is that everyone that voted in the negative to the motion of ought to pass as amended would like their minority report to be ought not to pass.
Correct.
Okay. With that, we wrap up the work session on LD 210. Let's take just a couple minute break, and we'll be right back at this. So a couple 3 minutes, 5 minutes is the request. 5 minute break. Okay. We'll be right back. Representative Ducharme, are you still there? Or yeah, Representative Ducharme, are you still there?
Yes, I am. Yes,
Did you want to
am.
record your vote? I'm sorry, I forgot to do that. Ms. Breton, are you there?
Yes, I am.
Representative Ducharme would like to record his vote for LD 110.
Representative Ducharme, the motion was ought to pass as amended.
Did you see what the amendment was? Were you able to follow along?
Yes, I did. I did. Thank you. And my vote is no, ought not to pass.
No, the other, you want your own amendment then? Because the other amendment was ought to pass as amended, but down to 10,000. But you can have an ought not to pass if you'd like one.
I would like it to be ought not to pass, period.
Okay, that's fine.
Great, thank you very much.
So we will have 3 reports off of that thus far.
Okay, thank you.
Welcome back. If folks can turn on their cameras so we'll know everyone's back. Thank you for that short break. We'll now open up the work session on LD 1168 and act to license operators of personnel hoists. And Ms. Olson, if you could walk us through this.
Okay, LD 1168, an act to license operators of personnel hoists, as that is a typo. All right, the bill summary. The bill does two things. So number one, the bill establishes the Elevator Advisory Board and changes all references to the director within the chapter to the board. So currently in statute, the director has the advisory or regulatory function over this chapter about elevators and tramways. And this proposed bill would establish the Elevator Advisory Board and give them the regulatory authority over those individuals. So it makes the change from director to board throughout the chapter. The bill also establishes requirements for the licensure of operators of personnel hoists. It creates exemptions to these licensure requirements for short-term emergency operation and operation by inspectors and operation of automatic operation or continuous pressure operation, passenger or freight elevators, or existing shipper rope elevators. Operators of personnel hoists would be licensed under the proposed Elevator Advisory Board, as the section related to licensing personnel hoist operators falls within the chapter for which the proposed Elevator Advisory Board would have regulatory authority. Potential issues or technical problems that I wanted to bring forward for the committee to consider. And this, some of these things were brought up as a result of testimony. The proposed definition of personnel hoist does not include an elevator, but the definition of elevator may include a personnel hoist. So it's just sort of the way in which you're viewing the regulatory authority with the use of that word. And then as the bill is currently written, the proposed Elevator Advisory Board would have the ability to make rules related to the necessary and proper administration and enforcement of Chapter 133, which is elevator and tramway safety, including but not limited to: 1, requirements for the safe and proper construction, installation, alteration, repair, use, operation, and inspection of elevators and tramways; requirements for licensure and license renewal of private elevator and lift inspectors, whose licensing statute is within Chapter 133; requirements for licensure and license renewal of elevator and lift mechanics, whose licensure is also under Chapter 133. So this brings up two possible issues. I'm going to scroll. And this was mentioned. So previously in statute, there was an elevator and tramway advisory board that was repealed in, look at my own notes, 2013. And so this, there was talk about how this is reestablishing that. But I'll note that the title says Elevator Advisory Board, but it would in fact still cover, because of the language saying that it has authority over the chapter, it does still cover tramways as well. And then with the addition of licensing of personnel hoist operators, it would also, personnel hoist operators would also fall under this newly created advisory board. So you could consider changing the title of the board to include tramways again. And you may want to consider adding personnel hoist to it, particularly if you think about how the definition of personnel hoist and elevator may be connected. If personnel hoist falls under elevator, then you could argue the title sort of covers everything. If you're considering those as being kind of two distinct groups, you could consider being more descriptive in the title. It is just a title, but worth noting. Information requests. The committee requested information on how personnel hoists are currently regulated within the state. Commissioner had provided information related to the steps taken by a state elevator inspector during the process of inspecting a newly installed elevator and a newly installed personnel hoist. Those documents include a description of an elevator owner's responsibility to have an elevator inspected and then certified by the state elevator inspector. Those materials were shared in advance of the work session to the committee by email. They're also in the electronic LD file. I believe that representative of a company in Maine that rents and installs and sets up personnel hoists also spoke about that process to the committee during the public hearing. There are requirements around the installation and the mechanics and inspection of the equipment. We heard from the testimony that it's that the company that is the inspector, the mechanic that's responsible for the equipment, trains an operator before sort of handing off the equipment to the company that is renting it or using it. And that information does have to be tracked, and they could check on it, but there's no license currently for the operators in the state. The committee requested information also on what other states have programs similar to the one proposed. And I'll admit that this one got, there's a lot of research that went into this. And I'm not, unfortunately, I feel like I still don't have a very clear answer to some of those questions. My researcher was able to identify that Hawaii, Illinois, Indiana, and Montana have such programs in place. And I've included that information to the end of the research memo at the end of the bill analysis. As I was doing the research related to crane licensing and looking into the OSHA rules that we just discussed in LB 210, it became clear that some states who license crane operators, the definition of crane operator includes what would be considered a personnel hoist or some machinery levels that would be considered personnel hoists, or their crane licensing legislation also licensed personnel hoist operators, with crane operator licensing being the more comprehensive one, and then a personnel license not covering as many types of equipment, personnel hoist licensing not covering as many types of equipment. And you can see that in the side-by-side that I provided for LD 210 in some of the examples there. It was mentioned during the public hearing that this bill would trigger a sunrise review, although I believe it should be noted that the decision for a sunrise review is a policy decision, although it is outlined in statute. The sponsor, Representative Roberts, did suggest that if moving forward, there are options for conducting a sunrise review that are not having the department do it, and one of those is to have a public hearing sunrise review where the language the proposed licensure structure is advertised with the criteria that are outlined in the Sunrise Review statute, are put out to the public, and the committee receives responses related to those or to that criteria, and holds a public hearing on the Sunrise Review criteria pursuant to the proposed legislation. So that was suggested. There was a talk of the previous Board of Elevator and Tramway Safety board that used to exist. It was talked about how this is reestablishing that. So I just looked up the history around that. It was repealed in 2013. The original bill that repealed the board was LD 414 from the 126th legislature. I did link the bill information page there. You can see testimony which was submitted by DPFR in support of that bill, which spoke to the reasons why they supported the end of that board, which Commissioner Head also spoke about in her testimony as well. And just to note that Commissioner Head was not, I believe, the commissioner at the time, or at least was not the one who submitted the testimony in the 126. There were a couple of things noted in testimony that I sort of included under the possible amendment section, but I think more are also just for the committee to consider. Ski Association of Maine opposes the creation of an oversight board and suggested removing the portion of the bill that creates the board, as well as making sure that the definition of personnel hoist does not include ski lifts. In addition to that, it was noted by some other groups who are currently licensed and fall within OPOR's elevator and tramway safety program, and who had previous representation on a board. They expressed concern that the newly created board doesn't have representation for those groups. The fiscal impact has not yet been determined. And I did include some information for your reference at the bottom. For example, the statutory definitions of elevator and tramway, which come from Chapter 133 on elevators and tramways. Tramway is quite long. And you know, this is where it does talk about really a lot about ski lifts, but also what you might think of as sort of gondolas or chair lifts. And there was a request for the standard code book that was referenced here, this ANSI AASP 10.4. I was not able to gain access to this. This is one of those protected books that they cost a lot of money to order. And just in the time to prep for this, I wasn't able to get my hands on a copy of that set of standards. And then I mentioned the research memo here details Hawaii, Illinois, Indiana, and Montana's an overview of their personnel hoisting licensing programs. I'm happy to answer questions about these, although I will just, before I close, I'll just note in particular, Illinois here it's really about mine shafts in particular, and Indiana also is really related to mine workers in particular. So I'll just make those two notes before closing off and taking questions.
Are there any questions for Ms. Olson? Seeing no questions. Representative Roberts, as the bill sponsor, would you like to address the committee?
Thank you, Mr. Chair. Yes, I would. Just to start off, as I mentioned in my original testimony, the intent was not to include tramways. So if this was to move forward, I would be amenable to the suggestion of taking them off the board as it is, as it's written, because that would include ski lifts, and that's not the intention. The intention is of the board as written was just to cover elevators, and that was how I thought it was written, but apparently not. And I would also like to point out that, so these outdoor elevators, they are not certified. There's no certification like there are for the cranes by OSHA. So this is another one of those safety and enforcement issues. I don't want to go through and belabor all of what are kind of the same points that we went through on the crane bill in regards to safety, in regards to enforcement, and everything like that. And there is a difference again with and without the OSHA certification being involved, where there is not one here. And again, this is to help make it clear, this was two bills that just kind of got merged together because they both said elevators. So we've got the licensing part, and there's a part that's reestablishing the board. So the board is not solely to oversee the outdoor elevators. It's the elevator advisory board, and then there's the licensure of the outdoor elevators. So, and I would also, as Ms. Olson had said, be open to doing a public hearing for a sunrise review so that doesn't incur any more costs on the department.
Ms. Olson, is there an obvious way to amend what you have in front of you to not have it deal with tramways?
There is a way to do it. I'm not going to claim that it's obvious, and I'm not going to jump to a quick fix for that. And as I am looking at it, we'd want to just go back because it does, one of the big changes throughout the whole piece of legislation, proposed bill, changes, as I said, the word director to board. And it does that for private tramway. For example, section 16 of the bill says the board shall license an applicant as a private tramway inspector. So it does, so there would need to be some changes there, and then also to where it says what the responsibilities of the board are. It's definitely fixable. Yes.
It's fixable, but not.
I couldn't just tell you right now exactly what we would need to do. There would need to be, I'd need to go through each section and make sure that the change to board only applies to the elevator portion and not to tramways. And then I would need to ask if it would also, if the purpose is to have the elevator board have the advisory capacity over personnel hoists. I would need to know that. So I'd have to then comb through and just make that change. And then I need to make one change, potentially one change within the structure of the board so that it doesn't say that it has oversight over the chapter, but over only the specific groups within the chapter.
And is that something that could be done via language review?
Oh, absolutely. Yes. Okay. We're in the habit, I think, of giving the exact language, but more often than not, I need to just know what the committee wants to achieve, and I'll go make it happen and bring it back to you.
And Chair, questions for me or for?
Chair recognizes Senator Searway. Any questions for, well, first I'll say, are there any questions for Representative Roberts? For Senator Searway? No? Representative?
No,
Searway?
it's for the Commissioner Head if later.
Okay.
Yeah.
I will ask Representative Roberts to get off the hot seat as the bill sponsor, and she'll come back into as the committee member, and we'll ask Commissioner Head to come in.
I believe Representative Ducharme's had his hand up.
Right. I'm going to let Senator Searway address this question to Commissioner Head first. Senator, go ahead, Senator Searway.
Thank you, Mr. Chair. Commissioner Head, in your opinion on licensure, is it a consumer protection requirement, does it actually pertain to safety or just consumer protection requirements? I'm kind of confused there because I always thought licensing was for the consumer protection and not for safety.
Senator, I think what we're talking about here is something that is difficult to describe. When the state goes through the Sunrise process. The focus is on Maine public at large. So a committee like this is tasked with deciding whether a profession jeopardizes the public, which is not necessarily the same as licensing parts of an industry. You don't license to make the licensees better. You license to protect the public. I think those are confusing concepts when you're talking about units being used in the construction area. It's a different setting. And we know people don't walk around in a work site where there is construction going on. They're not permitted to go in there. So I think you are looking at workplace safety, which is an entirely different concept from protecting the public at large from a profession that can inflict great harm on citizens. So that's the answer to your question from me. I look at things from that perspective. I can't make it any better than that. That they're two different concepts.
Right. And if they're certified, what is the difference between that and putting a license on them?
Are we talking about hoist operators now?
Any operator. I mean, it doesn't have to be hoist, it could be anything, but if you're certified, why would you need to be licensed? I mean, your company's licensed, you have the certification to do the job. What would the difference be? Why do we need the license? That's what I'm trying to ask. Why do we need that?
There is something about a state license that is issued that tells someone the state is standing behind this license. Certification isn't state licensure. It is different. It's the term is never used in state licensing. And I've been very careful to not use certification as a substitute for licensure. So it is a different concept. It's a set of standards that is applied by, in this case, the federal government to a set of employers who are responsible for the safety of the people they employ to do certain dangerous, operating dangerous machinery.
Right.
Chair recognizes Representative Ducharme.
Thank you, Senator Curry. I've looked at all of the testimony on this, and I kind of I remember Commissioner Head speaking in opposition to this originally in the public hearing, and I kind of was thinking about the whole idea of certification versus licensure. And if you go back to there's a license given by the state of Maine to drive on the roads, but it doesn't necessarily mean people are good drivers. And in this particular case, I think this is one of those things where I think that companies have a vested interest in making sure people are operating these pieces of equipment appropriately. And I think that they do. And I don't believe that a license is a state license is necessary in this case, for that matter, any more than I did in the prior bill. But in this particular case, I don't know if it's appropriate. Again, new guy, but if it's appropriate, I would make a motion ought not to pass.
There's a motion ought not to pass.
Second.
With a second. go ahead. And is there any further discussion? Thank you very much, Commissioner Head. So, and there's a motion not to pass in a second. Representative Roberts.
Thank you, Mr. Chair. I was hoping that we could hear from Bob Graham real quick, just regarding the board and the intended structure and the cleanup and how that's done, how it's going to look.
Go ahead and bring in Mr. Graham.
Good afternoon. Thank you for having me.
Thank you. Go ahead, Representative Roberts.
Thank you, Mr. Chair. Your video is off, Mr. Graham. Are you aware of that?
Nope, I'll turn it on.
Okay.
Won't turn on.
Go ahead with your question, Representative Roberts.
That's okay. Can you just kind of outline the purpose of the board itself and then the benefits of the license as you see it and in your position as
Sure.
that you're in right now, if you could kind of state to the committee.
And Mr. Graham, if you could introduce yourself and name what organization you're with.
Yep, my name is Robert Graham. I'm a business representative for the Elevator Constructors Local 4 at Boston and Portland. I oversee about 1,200 members through Boston and Portland. And, you know, the intent for the advisory board, I understand that it was disbanded back in 2013. And business agents prior to me have tried to establish this board back. And it's not, the intent of the board was more because back 20 years ago, elevator equipment didn't change that often. It might have changed every 15 or 20 years. What we're seeing now is that elevator equipment is changing every 1 or 2 years. They're coming in with machine roomless elevators, where it puts the people installing in dangerous positions. And it also puts the general public, because what they're doing with these machine roomless, they could have a controller in a closet that it's more of a building code violation, because when someone's in there working on it, they're blocking an egress or an access or an egress from the building. The advisory board was put in, what we were trying to do was assist Commissioner Head with people that work in the industry on a daily basis and can relay the dangers of this new equipment that's coming out to her, so that it was not the board to make any governing decision. The decisions would still be Commissioner Head's. The board was solely for the point of the way technology is changing at a rapid pace and the way manufacturers are trying to change code to allow these MRLs. There's one out there right now that ThyssenKrupp has. It's an MRL where it's a hydraulic unit. The tank is in the pit, and it's not allowed in some states because there's no refuge space. It encroaches on the refuge space. There was a gentleman killed in Ohio when the elevator came down and he couldn't get out of the way, and there was not enough refuge space, and he got crushed by the elevator working on it. Something that he's done 100 times in a normal environment. But because of these new manufacturing, what they're trying to do to limit building space and take up less room and give the buildings more usable space, it's putting the elevator constructors in harm's way, and also the general public, because of where these cabinets and controllers and stuff are going. You know, right now, ASME code is made up of 80%. When the voting goes through, it's made up of 80% manufacturers, and 4% are actually elevator constructors. So the bills get pushed through when codes get adopted. If it's just, the board was more designed to, I know that Commissioner Head's busy. We know that Mr. Burpee and Mr. Quinn are busy. It was more to give them because we know when new equipment's coming out, we see it and we can discuss it with them and bring it to the board and show, show them what the dangers are of these pieces of equipment. And that was the sole purpose of the advisory board. It was not to take any, I don't want to say power, but from Commissioner Head. It was more just to give her the knowledge of the people that work in the industry on a daily basis.
Thank you very much.
Thank you.
Yep.
Are there other questions, or are we ready to shift into debate? Representative Pebworth, was that a question, or did you want to, so you have a question for Mr. Graham? Thank you, go ahead.
Thank you. Mr. Graham, one of her concerns about reinstating the board is the number of volunteers necessary to pull together. I wonder if you have any thoughts about the list of board members.
So what I can tell you is that I've spoke with numerous members up there and numerous manufacturers up there. How we envisioned the board was a 10-panel board, which would be, brought up of Mr. Burpee or Mr. Quinn, a member, an elevator consultant, somebody that, a building owner hires and has them come in and they know the equipment. They know what's faulty. They know what needs to be replaced and stuff like that. A building owner, for the sole purpose of the fact that I was saying with these MRLs that they're putting in, and they're putting controllers in closets that actually, when you open it and you're in there working, it encroaches on the access and egress to the general public. So having a building inspector from a city or town on the board, a representative from the elevator companies, like I said, a quality elevator inspector. I am a quality elevator inspector. It's a national license. I know Mr. Burpee and Mr. Quinn are both quality elevator inspectors. The other one was a licensed elevator mechanic in the state of Maine, somebody that is out in the field and is working on these. A trade representative that's done installation and modernization, repairs, and service on these. I have numerous members that have asked me to, that they'd really like to get on this board. We did have a gentleman that retired prior to the board being repealed in 2013. And since then, we've had numerous people request to get the board back because they'd like to get onto it.
Thank you, Mr. Graham.
Thank you. Seeing no other questions, I'll ask Ms. Breton to shift Mr. Graham back to the attendee list.
Senator Curry, could I just add one thing?
Very briefly.
It was part of Senator Roberts. She had asked me about the license on the outside hoist. I'll make it real quick. We have that in Boston. I've been up in Maine. Any trade, anybody on that construction site can run that car. So whether it's certified that the inspector came out and said, okay, it's safe to use, if there's 40-mile-an-hour winds, you're not supposed to run these, but not everybody knows that. So there's definitely a benefit of having a licensed operator on that runs this car on a daily basis, that knows if something's making a weird noise, if something's not right, if it's too windy and it shouldn't be going up. They know this. Other trades don't know that, and they're just running them to get to their job, to their whatever floor they need to get to. That's it. Thank you.
Thank you. Seeing no other questions for Mr. Graham, if Ms. Breton, if you could shift Mr. Graham back into the attendee list. And I'll ask Commissioner Head to come back in. Welcome, Commissioner Head. wanted to give you a chance to address the last speaker, or I saw that you had your hand up, and
Yeah, I
this committee
did.
values your perspective.
Yeah, I don't mean to interrupt, but I just had a thought. It seems to me that there is some way to combine the crane operator concept with the hoist operator concept. A sunrise review for very few people who are personnel hoist operators doesn't really make much sense, but it does seem like there's a connection to construction, equipment, and those who operate them. So, setting that aside, that's a good suggestion, I think. Secondly, the elevator board, which is now called the Elevator and Tramway Safety Board, is set up in such a way that we are looking at everything that the Massachusetts people are looking at. We may approach it in a different way, but I wouldn't want anyone on this committee to think that we allow elevators or personnel hoists to be operated without the appropriate training, inspection, and acceptance testing that Massachusetts does right now. So, I understand the need to reconfigure things, but frankly, if there is this much interest in creating a new board for elevators, don't call it an advisory board, call it a board. Give the board authority to make decisions. The bill as it stands now gives the board all decision-making. My name or my position is not important here. I don't want any more responsibility, frankly. So why not think of it that way and take tramways with it? I mean, you can take the whole combination of what we have right now, form it in exactly the way you want to, and let it be an affiliated board. Then, as construction moves forward, and you want to add construction units to the crane operator board, you can do that. You can expand that. You can do the same thing here with the elevator board. Maybe it's time to do that. I will not, I know it's not the time to make these suggestions, but it's the only opportunity I have to make realistic suggestions for change. The bill as it stands right now, I don't think could be adopted and implemented. So maybe the public hearing is going to serve to explain some of the questions that I have. But as it stands, I understand the crane decision. I think this bill somehow relates to that. Thanks.
Thank you very much, Commissioner Head. What I'd like to do is request or give the have a corner caucus. So Senator Searway, I'll reach out to you. I'm taking maybe like 5-10 minutes. So I'll reach out to you once we're ready. So thank you very much.
Is it time for our afternoon stretching, group stretching?
I feel like we don't have enough stretch breaks. So, group stretching would be awesome.
We lead that, and then someone needs to videotape it and send it to the news channels, and we'll.
I think that would be fantastic. We used to have to do group stretching when I worked in manufacturing. So why not do it? And it was because we sat all day. So we're sitting all day. We should be doing it, the behind the back and all of that.
Welcome back, everybody. Senator Searway, looks like we're all here. So there's a motion on the floor, and that has been seconded. Representative Collmore.
Thank you. I'd like to speak to the motion on the floor. Given everything that we've heard and a lot of the language changes in the bill, I would support the current motion on the floor as ought not to pass. I don't think the bill, especially in its current state, is going to provide the intent that the sponsor is wanting to do. And in addition to that, I worry about the unclear definition of a personnel hoist, in that you could think about it as a scissor lift, or you could think about, though I know that's not the intent, it could be inferred that way. And that stuff does concern me, and how it will impact all different industries, not just construction. So I will be supporting the motion on the floor.
Thank you. Are there any other comments? Are we ready for a vote? Representative Austin, are you with us? If she arrives, we'll take her vote when she arrives. So it looks like we're ready for a vote. Ms. Breton, would you call the roll?
So I have not to pass motion made by Representative Ducharme, seconded by Senator Seaway. So if you're in favor of ought not to pass, you'll be voting yes. If you're opposed, you'll be voting no. Representative Geiger.
No.
Representative Geiger, no. Representative Andrews is absent. Representative Pebworth.
No.
Representative Pebworth, no. Representative Collmore.
Yes.
Representative Collmore, yes. Senator Lucchini is also absent. Senator Seaway.
Yes.
Senator Seaway, yes. Representative Ducharme.
Representative Ducharme, you are
We
muted.
can't hear you.
I think I saw yes.
That's what I thought I saw, but I couldn't hear him.
No, you have a second mute on. You want to try that? Try unmuting. Is there a microphone? Not getting anything.
I think his mic might be out, Mr. Chair.
Not yet. Do you want to try to hit the mic? I could tell what you're trying to say, and I just know the rules say we have to hear it. You want to try to hit the Karen on your microphone on the Zoom link and see if you can switch to a different mic? See if the computer itself has a mic.
Voting yes on my
Yes. Yes.
Thank you, Representative Ducharme.
And that was yes, correct? Okay, thank you.
Representative Austin? Representative Austin isn't. We'll see if she comes back. Representative Hassenfuss?
No.
Representative Hassenfuss, no. Representative Bailey?
No.
Representative Bailey, no. Representative Bernard is absent. She's traveling. Representative Roberts?
No.
Representative Roberts, no. Senator Curry?
No.
Senator Curry, no. Representative Austin, are you back yet? Even if she was back, the motion's gonna.
It's still yeah. So
3-6.
With three voting in the affirmative and 6 voting in the negative and 4 absent, the motion fails. Is there another motion? Chair recognizes Representative Roberts.
Thank you, Mr. Chair. I'd like to make a motion ought to pass as amended with the following amendments. You ready, Ms. Olson? Okay. To remove tramways from the board everywhere. Remove advisory from the board title. To clean up the definition of personnel hoist to reflect outdoor elevators only for the purposes like it's defined in the bill for construction, demolition, or alteration. And one more. Yep. And I don't know if we need to specify this or not, but that sunrise review would be done via public hearing.
I'll just note, I'm not an expert on that either, so it's something I'll have to ask and bring back.
Mr. Seneff crafted that, so I would defer.
Yeah, I will ask in the office just about how to go about doing a sunrise review by public hearing.
And Representative Austin, just to bring you up to speed, the ought not to pass failed. And your vote would still would have failed with your vote. So if you'd been here for that vote. So we're on to an ought to pass motion as amended, and Representative Roberts had just put forward that. Is there a second? Representative Geiger has a second. So the motion on the floor is ought to pass as amended with, let's see if I could summarize the amendment that Representative Roberts just put forward to delete the word advisory from the title, to strike tramways from all references so that the board does not address tramways, to clarify the definition that the hoist is an outdoor personnel hoist associated with construction and demolition, and to clarify that the sunrise review would happen within the committee, pending language review and appropriateness of that language. Did I get it all? All right. Is there any more discussion? Are we ready for the vote? Looks like we are. Chair, Ms. Breton, would you call the roll?
So I have an ought to pass as amended with all of Representative Roberts' changes. Motion made by Representative Roberts, seconded by Representative Geiger. Representative Geiger.
Yes.
Representative Geiger, yes. Representative Andrews is absent. Representative Pebworth.
Yes.
Representative Pebworth, yes. Representative Collmore.
No.
Representative Collmore, no. Senator Lucchini is absent. Senator Seaway.
Senator Seaway? You're still muted. Senator Seaway? Representative Hassenfuss, can you mute yourself for a moment? Thank you.
Yeah, I'm back.
There you are.
I'll tell you, I just went off into Zoom land somewhere.
Welcome back. The vote is to you. So.
Yeah, so it's no.
It's no. Senator Seaway is no.
I thought we were going to get there, but I just needed to hear it.
Representative Ducharme?
No.
Representative Ducharme, no. Representative Austin?
No.
Representative Austin, no. Representative Hassenfuss?
Yes.
Representative Hassenfuss, yes. Representative Bailey?
Yes.
Representative Bailey, yes. Representative Bernard is absent. Representative Roberts?
Yes.
Representative Roberts, yes. Senator Curry?
Yes.
Senator Curry, yes. 6 in
So
the
with-
affirmative, 4 in the negative, 3 absent.
With 6 in the affirmative, 4 in the negative, and 3 absent, the 6 will represent and ought to pass as amended. Shall I assume the 4 will represent and ought not to pass, seeing that that was just the previous motion? Anyone opposed to that? I think that's, and then we have a day and a half till the absentee members will vote. So thank you, Ms. Olson.
No,
What
that's,
do you-
I just, Representative Austin didn't actually register a vote with the last motion. So I wanted to just give her the opportunity to weigh in on a minority report here, since she didn't vote in the other one, just to make clear.
Representative Austin, were you ought not to pass in the minority report? You're muted.
I would say I am. I will
Okay.
be.
So you wish to join the minority report of ought not to pass.
Yes, thank you.
You
Okay,
were,
so-
you will be, you are.
I should, I could, maybe, I will.
Okay, so the minority report for this motion, Representative Collmore, Senator Searway, Representative Ducharme, and Representative Austin is ought not to pass.
And that closes the work session for LD 1168. Ms. Olson,
Yes,
do you have a language review for us?
I do. Let me pull it up. Topically, we are looking at LD 195, which the committee voted on. This is the majority committee amendment to LD 195, which I will pull up on the screen. So again, this is the majority amendment. Let me shift files so I can just pull up my rather hefty folder on this one. I printed all the testimony already.
Representative Roberts?
oh.
I just want to,
Yeah,
Representative
thank you.
Roberts, go ahead.
Yeah, thank you, Mr. Chair. In the essence of saving time, before we go into this, I'm wondering if I can make a motion to reconsider.
So a motion to reconsider in order to
Introduce
change-
an amendment.
introduce the amendment to the majority, introduce the amendment and then vote on the bill again.
Correct.
Okay. There's a motion to reconsider. I think that's a non-debatable motion as far as I recall. And so is there a second? Second. All those in favor of voting to reconsider? I think we can just do this by hand, as long as we can see a majority. 1, 2, 3, 4, 5, 6. There's 6. So the LD 195 is voted successfully to reconsider. So we'll continue from here. And Ms. Olson, you have, or actually I'm going to call on Representative Roberts. You are seeking to amend this bill?
Yes, Mr. Chair. Ms. Olson, I believe, has emailed out the amendment. This is basically walking back the previous amendment a few steps to kind of move away from a sunrise review, which is costly for the department. And what it's doing is instead, and I've again worked with the department on this to craft the language in a way that it was something that they could easily, or not easily, but easier do for us, was to provide a draft registration for general contractors. And then that would report back to us. It will have the same clauses as the other one, with a report back to us, and then our ability to report out a bill next session. So what we can do is take this draft registration program based on the criteria that we put forth, and then pick through it and say, we want this, we don't want this, we want all of it, we want none of it, it's for us to decide next session. This is to get us the information, and it's taking it down from a sunrise review just to getting what a registration that could be voluntary or not would look like. And that's overall what the amendment do. Ms. Olson can probably give a more technical, or did that about cover it?
So Ms. Olson, would you walk us through anything else that needs to be said in terms of this? So the original thing that was passed by the majority was to request a sunrise review for licensure for general contractors. This is an amendment to turn it into charging the department with developing a draft registration. Correct?
Yes, that's correct. So the majority amendment to LD 195 was directing the department to conduct a sunrise review for the licensing of general contractors for home improvement and construction. It outlined the definition for general contractor, dwelling and home improvement, and listed a few requirements for licensure to be considered. And it was noted and discussed that a sunrise review on something like this wouldn't necessarily be as fruitful as the committee may have hoped. And there have been sunrise reviews, which I shared during the bill analyses the first time around on the topic in the past. And so the amendment that I shared with you all by email and is also here instead has the department develop a draft registration program, which I went over with the committee earlier today, what registration looks like in terms of regulation by the state. It keeps the same requirements. So the definition, although formatted in a slightly more accessible way here, and it incorporates the amendment that was in the majority amendment, which would mean that if you were working on your own property on something that was not meant for commercial use, that you could do that without having a license. So it kind of outlines those things. Oh, excuse me, without being registered. Yes, in this case. Sorry, I was thinking of the majority amendment. Thank you. And then the requirements for registration may include, so again, these are things the department can consider when drafting the registration. And then as Representative Roberts mentioned, section 2 is that the department will submit draft legislation developed under section 1 to this committee by December 1st of 2021. And the committee is authorized to submit out a bill based on the draft legislation to the second regular session of the 130th, based on just means it was your starting point. So that's what this proposed amendment does. I can answer questions about the history, what we did before, or where we're at, if the committee would like.
Are there any questions for Ms. Olson? Seeing none, thank you. Are there any further comments or questions, or are we ready for a motion? Looks like we are ready for a motion. I don't think we've had a motion at this point, have we? We've just had a motion. So Chair will entertain a motion. Someone probably needs to talk. I can't make the motion. So, yep.
I make a motion ought not to pass.
We'll make it. We can do that. I see the motion, and great. And Representative Callamore is the second. So let's see. And so the motion ought not to pass is on the floor again. So Ms. Breton, please call the roll.
So I have an ought not to pass motion made by Senator Seaway, seconded by Representative Callamore. If you're in favor of ought not to pass, you'll be voting yes. If you're opposed, you'll be voting no. Representative Geiger.
No.
Representative Geiger, no. Representative Andrews is absent. Representative Pebworth.
No.
Representative Pebworth, no. Representative Collmore?
Yes.
Representative Collmore, yes. Senator Lucchini is absent. Senator Seaway?
Yes.
Senator Seaway, yes. Representative Ducharme?
Yes.
Representative Ducharme, yes. Representative Austin?
Yes.
Representative Austin, yes. Representative Hassenfuss?
No.
Representative Hassenfuss, no. Representative Bailey?
No.
Representative Bailey, no. Representative Bernard? Nope, she's in transit. I'm sorry. Representative Roberts?
No.
Senator Curry?
No.
So it's 4-6, 3 absent, so the motion fails.
Okay. Representative Roberts, I think you're in rights to make a motion here.
I was not sure with it being my amendment, but not my bill, so I wasn't sure. I'd like to make a motion ought to pass as amended with the amendment that Ms. Olson just shared.
Okay. Is there a second? Thank you. Second, Representative Pebworth. So ought to pass as amended with the amendment just reviewed. Ms. Breton, would you call the roll?
Okay, I called it ought to pass as amended 2 because you'd already voted on the first amendment made by Representative Roberts, seconded by Representative Pebworth. Representative Geiger?
Yes.
Representative Geiger, yes. Representative Andrews is absent. Representative Pebworth?
Yes.
Representative Pebworth, yes. Representative Collmore?
No.
Representative Collmore, no. Senator Lucchini is absent. Senator Seaway?
No.
Senator Seaway, no. Representative Ducharme?
No.
Representative Ducharme, no. Representative Austin?
No.
Representative Austin, no. Representative Hassenfuss?
Yes.
Representative Hassenfuss, yes. Representative Bailey?
Yes.
Representative Bailey, yes. Representative Bernard is absent. Representative Roberts?
Yes.
Representative Roberts, yes. Senator Curry?
Yes.
Senator Curry, yes. So it's 6-4 with 3 absent.
Is the theme of the day. So with 6 voting in the affirmative and 4 voting in the negative and 3 absent, we know the majority or the report from the 6 will be ought to pass as amended 2. Is the those who voted no? Is it accurate to say it was ought not to pass? Was your vote is what the minority report should say? I see nods from Senator Collmore, Representative Collmore, Representative Ducharme, Representative Seaway, and Representative Austin. Is that enough for you, Ms. Olson?
It is. Thank you.
Thank you. Okay. And so and we will wait for the final members based on joint rules to vote after the fact. Is there any, given that, we will close the work session on LD 195. Ms. Olson, is there any other language review? I hope there's not. No. No?
Okay, then no, I don't have anything else to bring back today.
Thank you very
but
much.
might not get off the hook so easy on Thursday.
All right, on Thursday, we'll be ready for it. So thank you very much. Is there a motion to adjourn?
So moved.
So moved. Everyone have a great evening. It's beautiful out there. I hope you can at least see some of it. So.